a berth, and since I am merely operating a berth, that's number one, please don't come. And in any case, number two, as your lordship says, that there has been an assessment which has taken place. So my respectful submission is that that's their preliminary reply. Now I'm going to show you what the court's finding, but this has huge implications for me. Because there's a huge in-transit coal which is coming in and which is being handled. So someone may eventually be able to say or persuade that, look, there's absolutely no pollution which is caused and therefore it's not exigible. But otherwise, on the face of it, your lordships at this stage will take the statute as it reads.
Mr. Diwan, there is a difference. It is not mere handling of coal within the territory of state of Goa, which is a taxable event. Taxable event is only when such handling leads to causing pollution in the state of Goa.
No, let us see it, Manoj. Please see the levy.
Yes, please see the levy.
Yeah, just first I'll just place before you the long title and then I'll take you straight to the levy section. To provide a levy and collection of cess, Manoj, long title, on page 1, on products and substances, sorry. Now,
itself.
Yeah. Now, look,
There shall be levied and collected a cess at such rates as may specified government notification so and so on.
Yeah. Exceeding 2% of the sale value of the products.
On or and or substance, the handling,
utilization, consumption.
Then this by any means causes pollution within the state of Goa.
Yes, of which by any means causes pollution within the state of Goa.
Unless it is found to have caused pollution, it is not a taxable event.
No, but I am not, Manoj, for a moment suggesting otherwise. I am not, but I don't think today it's not the case of the other side that it is not causing pollution. Please see, sorry.
We are only examining your case, that how did you issue notice? You issue notice.
We are at the stage of demurrer.
Yeah.
Because it's a challenge to your show cause, correct?
Yeah.
Does the show cause disclose that the handling had caused pollution within the state of Goa?
Yeah.
If you can show us that, you are definitely having a case.
Yes,
But if it does not say in the show cause notice that because of the handling, this is the pollution caused within the state of Goa, the show cause notice must fail.
No, I agree, but can I just respond to you straight away? Page 231. Just have a look at 231. I think for a show cause notice stage, this is adequate.
No. It is.
Please just look at page 231. Your lordship is 231. It actually starts at 230 of the paper book, P8. Because the show cause notice begins at page 230. Your lordship will see on the left hand side, about 10th line, the year is indicated as 22-23 on the left hand side. Now I'm on the right hand side, which is page 231, and I'm reading the 4th paragraph. Since the dealer failed to produce books of account for verification and there were no documents available on record to calculate the quantity of products and substances causing pollution imported by the dealer, the same was taken as nil and the assessment was completed. And whereas now it is revealed that the dealer has indeed imported huge quantities of products and substances liable for green cess into the state of Goa during the period and was thus liable to make timely payment of green cess. Hence, it is now clear that the entire turnover. Sorry.
Mr. Diwan, what is the actus reus which you have pleaded in the show cause? What is the offensive act you have pleaded? Import.
Handling.
Import. Where is handling? So there's complete non-application of mind. You are confusing the importer as the handler.
No, I have, please see, your lordship will just find that response. Your lordship may just go direct.
Go to the response, because the response is something which if the High Court or we see, we are actually expanding the scope of judicial review with regard to show cause notices. Show cause notices must survive or fail on their pleadings. And if the pleading is one of an importer, it's a clear non-application of mind.
Look at 262. Please see page 262. My communication begins at 257. This is one of the impugned communications before the High Court. Beginning at page 257, annexure P12. Your lordship has that, 23rd May 2025. Now please go directly to page 262. As per your contention, the company is merely an operator of berths at so-and-so port, Goa.
The response.
Feel clear?
What he's saying, I'm not an importer. Importer is JS.
Yes.
Team.
No, but I have said since the company is handling the imports, a show cause notice, and I have said handling, my lords. Your lordship's question to me was, where have you asserted handling? Your lordship will find that in the third paragraph after the quotation of section 4.1 at page 262. But surely when a government issues a show cause notice, this is not a case for interdicting at this stage.
Even
You may ask for further and better particulars. Sorry.
in this order also, Mr. Diwan, the assessing authority is
Yeah.
proceeding on the premise
Yeah.
that handling of coal itself is a taxable event.
Yeah.
Here also the detail, again we are pointing out that itself is not a taxable event, it is qualified.
But I am saying, today, your lord, but I am just saying today.
No.
Okay, let me put it differently.
Can't issue a show cause notice
Yeah.
unless
Yeah.
you have material with you to
Yeah.
show
Yeah.
that this activity of handling has caused pollution.
And that.
No, but
And that material you have to show.
Reassessment. It is nil assessment.
I am saying, your lordship is correct, Willards, in the general approach. I'm not quarreling with that. I'm just asking myself, is there a cess on handling of coal? Which is the thing. Now, what your lordship is putting to me is a very pertinent question post adjudication. Today you are at a stage where at the show cause, because if this is the point being put to me, I will have to adduce evidence to show that there is pollution as well. Today the authority proceeds on the basis that if there is handling of coal, because the statute says handling of coal causing pollution. So the coal is coming, it is coming on the berths, it is being downloaded, offloaded. Sorry.
This argument, sir, if it were at the assessment stage, would be accepted. When it comes to reassessment, there must be some
That's
additional material.
Just go to page 79. Page 79 of the SLP paper book. You also come up with a further evidence. Look at page 79.
It's proportionate taxation.
Yeah.
All activity of one poster.
I'm just asking you, then may I just take instructions? I'll come back to your lordships and show if they are able to show that prima facie handling of coal also results in air pollution, because your lordship has seen, then I'll place it on record. If there is no air pollution, your lordship has expressed a view. Sorry.
Said why we brought out this for you on reassessment. If you accept, we won't entertain but keep the issue open. Question open with regard to handling, whether you could issue a show cause notice in respect of handling, because until and unless we hold that, it may be binding precedent.
Yes,
it would embarrass your client.
But that's a
that
huge
we
problem
can
for me.
keep the issue open in appropriate case to be decided. But what we feel is in the facts of this case, we won't be going into this question.
But 226 is a stymie. Just look at page 79.
226 we know, 226 we...
Look at page 79. The reason why.
Must be sparingly entertained, but once having entertained, we have to decide.
Yes. Well, all right, just have a look at 79. This is on the second question, Manoj. Page 79.
In this case, because of the delay part also against you, but anyway.
No, just have a look, Manoj. Your lordship has ground N at page 79
Yes.
of the SLP paper book. This fresh material, including birthwise, year-wise data of commodities handled, the Pollution Control Board's criminal complaint for handling beyond the permitted limits, and the Legislative Assembly questions data constituted tangible, objective information sufficient to form reasons to believe that the petitioner's turnover and handling had escaped assessment, thus justifying an initiation of reassessment proceedings. The impugned judgment erroneously proceeds as though there is no material at all. So, this was what triggered this whole, there was a GPCB issue, there were questions which were asked, there was sufficient material. Now, I just ask myself, if your lordships are pleased, there are two suggestions that I have. One, I'll of course take your lordship's observation that the question of law is kept open. But the other point which I'm suggesting is
that we can protect you, because probably what has happened, Mr. Diwan, your authorities have taken the statute, like ordinarily when the cess are imposed, that merely you allege an act and then it becomes a chargeable section.
Yes.
Unfortunately, they have overlooked or ignored the important part of that
Pollution causing.
pollution part.
No, I understand that. So, may I just
So,
make
for example, in a case some complaint is filed or pollution control board passes a note,
Yeah.
that is a good justification for your assessing authority to issue a show cause notice.
What you are saying,
We have found causing
GSPCB complaint,
Yeah.
that the handling itself is causing pollution.
Yeah.
If that is placed before an authority.
But that's exactly what that's my permission, that I'm just suggesting to the court.
But this is.
Please allow me, no, I'm just suggesting, because ultimately we have.
For the first time, this is not at all in your pleadings before the High Court.
No, I did not, I picked up, we did not, don't say.
Now these things are being brought on board to justify an action.
Yes, but may I just suggest this, would your lordships consider not standing it over? Let me come with an affidavit regarding the pollution caused by coal handling.
But that will be completely reopening everything.
No, but that will at least satisfy the court if there is satisfaction to be.
We find some merit in your ground end. But what we see ground end surfaces for the first time in the SLP, they have not got any opportunity to rebut it. Nothing.
What has happened
And
here?
how can we blame a High Court who is not made privy of this ground?
Yes.
Either it is argued and it is canvassed that the High Court has erred because of this ground.
But the only other, sorry.
On that point.
First, we can permit you to withdraw and file a review petition before the High Court if you have some material to show.
Lord,
Because maybe that.
may I just point out something? May I, with your lordship's permission, point out
So
something?
if they want to withdraw.
No, I'm just saying something. I just wanted to point
All
out
right,
something.
your lordships may allow me. I'll withdraw my lords with liberty to.
No, I
approach.
just wanted to bring to my lord's notice, before your lordships pass that order, it's subject to your lordships permitting. This SLP is for the period 2014 to 2022. Something very important which in fairness they should have pointed out to the court in the SLP, not pointed out, is that for the subsequent year 23-24, the assessing authority has passed an order on merits, and that is a short order which says that we are only cargo handlers, we have not committed the import, and therefore there is no liability on us. This is for the subsequent period after all this.
324.
So as was falling from the court, the foundation of a case is to be contained in the show cause notice. This aspect which they are now seeking to urge is not even there in the High Court in their counter affidavit. Number two, my lords, and very importantly, the High Court has pointed out that JSW, which is the importer, is paying tax, is paying cess. And what at the third point is, my lords, if the importer is paying tax, what was not shown to your lordships, and which is most crucial in this case, is section 4.2. Section 4.1 is an enabling provision which permits various activities to be brought to tax. 4.2, which we challenged, said that we allow the state government to impose tax on whoever it likes, and therefore rule 3. Now kindly just see rule 3 with me, which is quoted, my lords, in the impugned judgment at page 15. That rule says, my lords, that it is up to the state to determine at what point will they tax. And the proviso to that rule, which is very important, says it is up to the state also to increase the number of points. So therefore, if I am an importer, the state can impose tax on me. And if I am a handler, it is open to the state by notification to add that as a taxable event. And the High Court notes in 2 paragraphs that we have put it to the state that have you used this rule to also impose tax on others who handle, and the answer is no. So what they are seeking to urge before my lords actually is something beyond their own section and rules. That's why the High Court says that once you are taxing the importer, that's the end of the matter, unless you amend your rule. Kindly see rule 3, page 50.
Perhaps the High Court may not have been right that 4.1 will be circumscribed by rule 3.
No, I'm not saying that.
So that is the foundational issue.
Probably,
the High Court
probably, my lords, I did not explain myself. What I was wanting to say is, section 4 is in 2 parts. The first part creates the charge And it is an enabling provision because subsection 2 of section 4 says,
The first part cannot be an enabling provision. First part creates the liability. That is the
Yes.
chargeable section.
Charging section.
is,
Subsection 2 is the method and procedure in which it is to be levied.
Lordship, please.
Now, one is to be given effect.
But there perhaps they use the word brought or caused to be brought, and there the argument is that brought and caused to be brought can only be by an importer, and hence the chargeability is reduced only to an importer. It's a debatable proposition.
I see what is.
It's a debatable proposition
I see.
because the width of a parent statute cannot be whittled down by a rule. However, what we are not with Mr. Dewan is impulsive handling within the state of Goa will amount to an unconstitutional provision
Lordship.
because it would impede free flow of goods and services
Within this.
between in the country,
Lordship.
which is
I see what.
impermissible
I see.
in taxation regime.
I see what is.
Your Lordship may keep the question of law open.
Yes.
We have heard from the National Council, staff of the state of Goa and the colleague, Senior Council representing the respondent association MKVA. We see no ground to, in the particular facts and circumstances of the case, we see no ground to interpret with making judgment of the reports or the question of law, and especially with respect to interpretation of section 4 in bracket 1 is kept.
Lordship.
Grateful.
These are those faceless.
These are those faceless cases, my lords. They're coming on the 6th of April, the batch.
They were on 6th April, if you notice, tag with on so and so date, 6th April. Unlike the regime mentioning the application, the same without the trial could be granted. 3 months more time to, 2 months they are asking 3 months more time to conclude the trial. Item 43 and 41 subvention matters today, main case is there, whatever will happen. We will take up with the main case. Item 44.
Was in item 44, Ms. Talekar is appearing through VC Lords.
44, I am requesting for pass over. I'm only requesting for.
Sorry, my apologies, sir. What's this, the interim order says no precipitative steps. Now that aggrieves us because after 3 years of the order having been passed, they suddenly file a writ because elections. This has nothing to do with the dairy producers, Manoj. 1,200 of them sent into liquidation within 24 hours. 1,200. Just one standard format. Fortunately, that order is stayed within the statutory 30-day period. There is absolutely no problem. The elections can go on as they are. This becomes a completely political issue. I am the MLA for Kolhapur. I have all these dairy farmers coming to me and saying our cooperatives are sent into liquidation when we are facing very serious issues regarding a drought, regarding the fact that we are somehow maintaining our 50 liters per day.
Point out these things to High Court, Mr. Gopal.
I agree, Manoj. It was listed yesterday. It's been now listed for 17th. But in the meanwhile, the problem is that these election processes.
That's why the High Court is also realizing some urgency in the matter.
I agree. So I will not press this further. Will Lordship give me permission to withdraw?
We will simply say at the outset, Land Senior Counsel for the petition informed that the case is now listed before the High Court on 17th March 2026. Therefore, in that being so, we are not inclined to entertain this special petition.
Yes.
And disposing petition with liberty to the petitioners to raise all their contentions before the High Court on the date fixed.
Very good.
We request the High Court that in light of the urgency shown by the petitioners, the issue the interim directions may be hard on the date.
Very good. Very good. On the other side?
Yes, on the other side.
Let's show all this.
Item 15,
So this is regarding that compliance that we had to, of that cancellation of that deed, there was a contempt petition that was filed. I had made a statement on the last occasion that we'll need a little more time.
cancellation deed.
Yes, for the cancellation. The problem is in Bangalore, they're going through a regime change as far as the corporation is concerned. So we have made our efforts. The corporation has to digitally move to a different scheme. That is what is causing the problem with the cancellation. So I thought in fairness to show our bona fides, there are one of two options. We have filed an application, it won't be on record. Yesterday we filed an application to implead, Manoj, the, implead what? Talk to me. The Greater Bangalore Authority. The Greater Bangalore Authority is the one that has to cancel this sale deed.
That will have to register the cancellation deed.
Register the cancellation. So that, there is a technical issue that they are facing. Yes, talk to me if you don't do this. The last order is open, everything and cheap it, I don't know. What are we doing the office with you guys?
I guess I just.
Technical problem, no application will follow the problem. Yes.
When the main matter is taken up, I'll demonstrate actually this contempt would not lie because it doesn't deal with that land in any event. But there's no question, we have given our undertaking here, we will ensure that the cancellation takes place. The technical issue is not in my hands,
Well, here the
which is why
difficulty is-
if your lordships may issue a direction perhaps to this authority to register the cancellation, that is one option. I have an application now for their impleadment, my lords, because this is as much as we can do. We have
Right.
kept it going.
So, please, their authority, we call them unnecessarily, we can direct it.
Maybe.
Lordship may direct.
But here what happened, agreement to sell was registered, my lord, for the undivided share. Now, my lord, they say that was registered without any further requirement of khata being.
Anyway, that is not the issue now. The problem is that because of the bifurcation of the municipal corporation,
Bifurcation cannot be done till such, because it's undivided joint family property, my lord.
bifurcation of the corporation, madam. In Bangalore now there are 4-5 corporations, that matter is separately different.
That's
So because of that some complication, they have submitted the cancellation deed, which is not being registered. So which out of these now new corporation, which one will register it, Mr. Gopal?
I'm sorry, Manoj.
Out of these 4 or 5 new corporations now,
Greater Bangalore Authority is the authority which has to
Greater
process.
Bangalore Authority.
Greater Bangalore Authority.
So, having regard to, say it is stated by Shri Gopal Shankar Narayan, Land Senior Council, that Land Senior Council representing respondent 1 and 2, say in continuation of the orders dated so and so, in continuation of the orders dated 10th October 2025 and 4th February 2026, it is stated by Mr. Gopal Shankar Narayan, Land Senior Council for respondent 1 and 2, that the deed for cancellation of sale deed has been presented before the Greater Bangalore
Authority.
Greater Bangalore Government Authority of Bangalore.
Greater Bengaluru Authority.
Greater Bangalore Authority. However, the same has not been registered on account of the issues pending re-bifurcation of,
For e-khata preparation is the
on
reason.
account of introduction of some new IT-based
Yes.
software for registration of documents. So, keeping in view the nature of issue involved before us, we direct the Chief Executive Officer of the Greater Bengaluru Authority to register the cancellation deed
Dated 6/10/2025.
dated 6/10/2025 within 2 weeks and send a compliance report.
That will be.
Give the status quo.
In the main.
Compromise got the secret.
Very compromise is in charge.
Of the fault that we should.
This property will be dedicated.
First we are struggling hard for the purging of contempt, then we will see what is to be done. Don't tell me to do that.
No, that is part of the.
What is law of the-
I'm not part of the sale deed. This document what my learned friend is appearing in, I have nothing to do with it. I've been impleaded for some other property, my lord, which is not even a suit schedule property.
Original plaint for status quo is regarding only the entire property.
Suit schedule. I've been deleted from the suit schedule in
Not-
2016.
That's what.
If I may, in the initial suit, when they filed for partition of all these lands, there were compromises that were entered into at various stages. Eventually, they filed a 6/17 to amend the schedule. That was allowed.
And
There was
I-
no objections taken because in the partition, Manoj, everybody is a plaintiff and a defendant.
not by us.
Nobody objected.
My
So the
property is deleted.
schedule shrunk. So now when your lordships ordered status quo, we were all under the impression that it's only on the amended schedule. Which is why we don't believe there would be a contempt, but in any event, this stands.
Not-
as
In
it-
my case,
when
I
the main matter
was
We are
deleted
not
as a
part to
party.
any of the compromise, my lord.
I'm
The
not-
issue before the High Court was that.
I was deleted as a party in 2016 on an application. A, I was deleted as a party. Two, the property was deleted from the suit schedule. My lord, before the compromise of 17, which has come up before your lordships, I was not a party at all in that compromise. I don't know why I've been brought in, my lords, as a respondent here. And her father, the petitioner's father was a party to all this transactions, my lords. And in fact,
Under compromise.
the compromise which says and the amendment by which I'm dropped as a party. I'm dropped as a party in 2016.
Father.
Whoever it is now. Whoever it is. Two Bengaluru block.
My lord, in fact, I moved an IA also to be deleted as a party. Your lordship will hear it anytime, but please, I'm on a different footing, my lord. Because in my case, I'm a different company which they were a party prior to all these transactions, it's been sold.
Same.
And they themselves have filed an IA saying that they to be deleted because they are not parties. This property is to be deleted. No, my lord. I'm sorry, my lord, please don't. This is not that kind of case. This is a case, my lords, where they themselves have deleted me. There are orders of the court. Plaint has been amended. I have, please, you are a party, your father was a party. I have been deleted.
Let us wait, let us see.
I have been deleted as a party, property also deleted.
First, we are concerned that our order is respected, then we'll see.
Yes, this I'm not, my lord, so far as the sale deed they're talking about, I'm not a party there at all. I have nothing to do with that.
That's why we are saying that we will hear you also.
Or contrary to the orders of your lordships are constructing and selling the property.
Let us take it after 2 weeks, we'll see what is to be done.
My lords.
Item 16,
No, one suggestion, can I have that order out today because BD, they are not a party, the Greater Bangalore Authority, then I'll take it and give it to them and ensure that compliance is done immediately. I'm grateful.
mostly released. Item 16,
But specific date will be given, Lords?
will you do?
Grateful.
Grateful.
May I please, Lord? Lord, at the very outset, Lord, I just wanted to show the order part of losses, Lord. In this matter only, Lord. When Lordship has pleased to observe, Lord, in paragraph 4, Lordship please see,
We
Lord.
had earlier dismissed it.
Earlier, Lord, because charge sheet was not filed, Lord. Thereafter, Lordship may see the order, Lord, paragraph 4, Lord. Having, please circulate, of the orders of my Lord, Chief Justice, Lord, at paragraph 4, Lord. Having regard to the fact that the offences are alleged who have committed in different parts of the country, learned state councils as well as the council of the petitioner shall have instruction as to why the investigation of all the such cases be not interested to,
Therefore, we have permitted you to see clubbing after the charge sheets are there.
pardon me, Lord?
We understand how are you interpreting para 4.
My Lordship, in that case, my Lord, in this writ, my Lord, was allowed. And the sureties were directed to be clubbed, my Lord. The judgment is, I have been asked, my Lord. What I submit is in this, my Lord. Kindly appreciate, my Lord. I have already undergone, my Lord, incarceration for 4 years, 6 days, my Lord. Lord, the FIR span, they are spanning 5 states, my Lord. I am seeking guidance, my Lord. My Lordship, either my Lordship make club, my Lord.
Deposit करने को.
Or my Lordship, I am agreeable, my Lord. Pardon me, Lord?
This one, how much amount have you defrauded?
My Lord.
500 crore only.
Pardon me, Lord.
500 crore only.
There is, my Lord, even if the FIR I have made charge.
You deposit 500 crore with our registry, then we will provide you excellent
My Lord, the FIR.
7-star trial,
Lord,
wherever you would like.
the FIR also not. Lord, in the sum FIR, there are 39 lakhs, 40, 50 lakhs, my Lord.
So if the total amount comes around 500 crore, you deposit that amount with the registry.
What?
Then wherever, if you would like your trial to be conducted in England, or in Dubai, wherever you want, we will make arrangements for you.
Here we be for a moment. What I am submitting this, Lord. I have filed.
The second alternative, the only ground taken by that you are traveling different places.
Yes, yes, Lord.
After all, you are also Gandhi, follow Mahatma Gandhi, travel the entire India.
What I am submitting this, Lord. What I am submitting this, Lord. I need to see for Lord. We are able to that, Lord. Lordship made correct, Lord, that all that investigation they FIR. One is, Lord.
Thank you very much. No case to interfere made out.
Second,
Dismissed.
what is this, Lord? Lordship made that presentation, Lord, in that case, Lord.
Oh,
At least grant me liberty to appear to VC at least, Lord. Grant me liberty, Lord. Then petition will.
go and apply to the court.
Lord,
Go and apply to the court. If the court will decline, then you will go to High Court. If the High Court declines, then you will come to us.
may observe one sentence, Lord.
No, you don't require any observation. You have a right.
This,
Go and avail your right, please.
Whatever meager amount due, you said 37 lakh, 40 lakh, deposit that in the trial court, get exemption.
Thank you very much. Thank you.
My Lord, in 17, your Lordships may kindly pardon my physical presence. My Lord, I recovered from a little serious viral thing. My Lord, I am recovering from that. My Lord.
Sorry.
The officers are present. We have filed 2 affidavits, my Lord, tendering an unconditional apology. And we have also published a 1-line unconditional apology, my Lords. Lord, one more thing I am instructed to say. Lord, the state government, central government has already directed NCERT to review textbooks of all standards, my Lord, not just 8. Lord, from the context in which, my Lord, we are looking at it. We have already, my Lord, instructed.
The Solicitor General, instead of leaving it to the NCERT, we would have appreciated if the central government itself constitute some high-level committee.
It shall be done, my Lord. I have no argument. It shall be done. It would be neutral, independent, domain experts.
Now, that is one way that we thought and we expect that this at least now after tendering unconditional apology and realizing that what a blunder has been committed by this NCERT.
My Lords.
This affidavit is an eye-opening that the curriculum is issued without getting it approved from at any level.
Your Lordships are right, my Lord. I have no.
If you believe your affidavit, then accept this learned professor, this Michael Danino, and these 2 central persons, one's
Yes,
and Alok Prasanna Kumar. After that, the matter should have gone before the committee.
The body, my Lord, page 4, para 7, I have, my Lord, very candidly, and I am bound to, my Lord, admit that it didn't go to anybody else. Selectively, some people were sent digitally. And, my Lord, this needs a systemic change, my Lord, which we have already started. Page 4, para 7, my Lord, what your Lordships are saying.
If this is the casual way of publishing the curriculum for the students in this country, Mr. Solicitor General, what do you expect us to?
My lord, we have started systemic changes. It has already started going on. We'll place it, my lord, before your lordships. And for reviewing, my lord, whatever textbooks are already there, my lord, I can make a statement that we will have a committee of independent, neutral domain experts.
Going to be formed consists of domain experts because there are other problems, not just with that chapter, Malad, there are problems throughout the text, Malad, and I'm sure with the solicitor there,
We are.
Yes, yes, not concerning this chapter.
that all aspects will be looked at of that, that's all that I.
Problem we will.
Yes,
examine.
my lord, I fully agree with my learned senior, my lord.
As of now, we are only concerned about that.
No, I know, Malad, but since he's forming a committee, Malad,
Manner in which some anti-social element have reacted also.
Right.
It's not that, and I'm not a person who is going to leave these elements also. I know how to.
they have given public speeches, that's why I've seen that myself, Malad.
It's not, they must also realize how to deal with the current Chief Justice of India. I will deal with them also. But right now, the question is that they have realized their mistake, there is an unconditional apology. We are not something that we are having any.
But your lordship, kindly see, Lord, your lordship, this court has already laid out the parameters in a matter where the majesty.
Sir, please, but we don't want any assistance. We know what is the issue and how we have to deal with.
The Delhi Judicial State of Gujarat, your lordship knows that. When a judicial magistrate was not paraded on the street by the policeman, Lord, your lordship has taken cognizance, judicial cognizance.
Many other aspects of it.
Education also present here.
Yes, my lord.
Mr. Kumar, in your affidavit, please read para. No, not in your, this is in the NCR.
The longer affidavit is NCERT, my lord.
Our worry is that you say that you have rewritten now. Who is,
No, but not yet given effect to. my
Lordship.
lord. I can assure.
Lordship, we are the interveners in this matter.
paragraph 15.
NCR
Yeah.
that in light of you have rewritten the chapter, that is what you say in paragraph 15.
The chapter 4 of subject textbook has been duly rewritten. Who has rewritten it?
My lord, it will not go into the textbook.
And duly, has been duly rewritten. If our grammar, understanding of grammar is not wrong, it is already done.
My lord.
And that is why you say has been duly rewritten. Then where is the chapter and who has done it?
Yeah, but my lord, we have the experts, our faculty members and all experts.
Sir, it was expected of you.
Mr. Chairman, please allow me to speak.
The so-called experts who has rewritten it.
They are.
My lord, may I say something, my lord? May I say something? My lord, that chapter will not go into the textbook unless, my lord, the committee which your lordships have in contemplation examines not only this chapter but everything. Your lordships can record my statement.
Only thing which is troubling us is paragraph 15 where the director NCRT says that after this was flagged about the contents of the chapter 4 has been duly rewritten. Next line, now we don't understand how and in what manner it was rewritten, who were the persons who have rewritten it, and what is the present contents of that rewritten chapter.
Lord, I will place that on record, but would your lordship see the next
We are
sentence?
saying it is after this sort of a concern expressed by us, this is the manner in which a deponent, as responsible as the director of NCRT, comes up with such a laconic statement.
Lord,
Which is,
Lord, may I request your lordships to read the next line, my lord? Possibly
after
that might
writing,
clarify.
well, just a minute, after writing that it has been duly rewritten, next it is further submitted that the revised chapter shall be incorporated in the fourth academic session 26-27 and shall be used for classroom transaction school across all states in accordance with applicable curriculum and academic framework. What is that applicable curriculum? What is that academic framework? We have already suffered.
My lord, I can assure your lordships, my lord, nothing will go as a textbook without being vetted by the committee of domain experts, independent of the government, my lord, having vetted it.
No talented person is there. Very years ago, people abandoned and they reached the institution.
On 26th February 2026, school, from after reading a news item in the newspaper Indian Express. After reading an article published in the newspaper Indian Express, dated 24th February 2026, regarding the social science textbook of for grade 8 in bracket part 2 titled so and so, published by the National Council of Education, Research and Training in bracket NCR part 2. When I took so much cognizance of the repeated opening contents of the said chapter and consequently issued certain enduring directions of offending contents of the chapter which were expressly meant for maligning the Indian judiciary. This court therefore issued certain interim directions as contained in para 21, as contained in paragraphs 15 to 21 of the said order. Next paragraph. In purported compliance thereof, Professor Dr. Dinesh Prasad Saklan, Director NCERT, has filed an affidavit tendering unconditional and unqualified apology on his own behalf and on behalf of NCERT for inclusion of the subject chapter of social science textbook for grade 8 in bracket part 2. Since certain information was sought from him, he has disclosed in the affidavit that the offending chapter was drafted by the textbook development team in bracket TDT under chairmanship of one Professor Michael Deshno, who is reported to be a visiting professor IIT Gandhinagar. The board members, Ms. Suparna Divakar and Mr. Alok Prasanna Kumar, were also associated with Professor Danino for drafting the subject chapter. Next paragraph. As per the prescribed procedure, the draft curriculum was not to be deliberated amongst the members of National Syllabus and Teaching Learning Material Committee in bracket MSTC, comprising 19 persons, details whereof are given in para 6 of the affidavit. In para 7 it is explained that the draft chapter was not placed before the MSTC except that it was circulated inverted commas only amongst the few members digitally inverted commas close. It seems that the Government of India from Ministry of Education, Government of India Ministry of Education, took cognizance of the offending contents, and on 24th February 2020, contents after the news item was after the publication of the article in the newspaper, and directions were issued to all the copies of the book which had been published meanwhile. Called all the books, all 82,440 books which had been published meanwhile. Published spoke circulatory meanwhile. It is thus stated in the affidavit that all necessary and urgent steps have been taken to implement the interim orders of this court for withdrawal of the next further. However, we find para 15 of the affidavit of the Director NCRT while disturbing where, despite the fact that the state is seized of the matter, it is stated that in terms of directions issued by the Department of School Education and Literacy from a Ministry of Education, from a chapter 4 of the subject textbook has been inverted commas duly rewritten, inverted commas closed. It is further stated that inverted commas the revised chapter shall be incorporated in the forthcoming academic session 2026-27 and shall be used for classroom transactions in schools across all states and union territories in accordance with the applicable curriculum and academic framework. Inverted commas closed. Next paragraph. Neither the affidavit nor otherwise this court has been that this court has not been apprised either through the affidavit or otherwise as to who are the alleged subject experts, domain experts who have inverted commas rewritten the chapter again and who has approved it for incorporation in the curriculum of the academic session 2026-27. So, suffice to mention that one after the other hasty act is likely to create more complexity with reference to an objective, transparent, honest, and dispassionate information that ought to be brought in public, that ought to be incorporated in the curriculum with respect to the judiciary or for that matter any other institution. Next one. Mr. Sanjay Kumar, IAS, Secretary, Department of School Education and Literacy, from Ministry of Education, Government of India, has also filed a short affidavit of unconditional and unqualified apology and has further stated that the ministry has already taken apology step. He has further stated that the ministry has already taken systemic steps to ensure that such an eventuality does not reoccur and will take further steps in the direction which are in the process. According to him, he has been advised not to give details of such steps at this stage. That's all. We have heard briefly Sources Prasad Mehta, Land Sources of India, and Mr. K. Mehta, Land Additional Sources of India. Both the officers are also present in court. At the outset, next paragraph, at the outset, we have no reason to doubt that Professor Michael Janino and his associates, Ms. Suparna Divakar and Mr. Alok Prasanna Kumar, either do not have reasonable informed knowledge with respect to the Indian judiciary and or they deliberately and knowingly misrepresented the facts in order to project a negative image of the Indian judiciary before the students of 8th class who are in an impressionable age. We see no reason as to why this kind of persons be associated in any manner for the purpose of preparation of curriculum or for finalization of the textbooks for the next generation of children of this country.
Or for any other purpose.
Consequently, we direct the Government of India and all state governments, stroke union territories, all universities, public institutions receiving government funds to disassociate two of them forthwith and not to assign any responsibility which incurs fully or partially public funds. This order, however, shall be subject to their approaching this court for modification, along with an explanation, if any, they wish to tender. Next paragraph. Similarly,
Only one thing, we have already said on our own that we are disassociating them. So they cannot come here.
that order is only that they are disassociated from NCRT.
Yes, we can do that.
One of them is appointed vice chancellor tomorrow.
I bow down.
It is thousands of students like this.
I bow down, Your Lordship, sir.
It seems to us that the Government of India should also revisit the composition of NCSTC. While we do not wish to comment against any person, some of whom are undoubtedly eminent public person or educationist, NCTC, especially those with whom the offending chapter was digitally shared, though without making any individual comments against any member. Ordinarily, it is advisable if such committee is comprising different domain experts.
That's what.
So, if NCRT wishes to teach the next generation of students about judiciary, we find it slightly disappointing that not a single person who can be, not a single eminent jurist has been included in that committee. So, we, however, leave it to the entire decision of the competent authority for reconstitution of NCTC. Next paragraph. We are equally perturbed with the stand taken by the Director NCRT in para 15 of the affidavit. We direct that if at all chapter 4 of the subject textbook has been rewritten, the same shall not be published unless it is approved by a committee comprising domain experts. We direct the Government of India to constitute a committee of domain experts, which may preferably include one former senior judge, one eminent academician, and one renowned practitioner. One renowned practitioner in law. Next paragraph. We hasten to reiterate paragraph 9 of our order dated 26th to say that the interim direction issued on 26 February 26 or in today's orders are not meant to are not intended to prevent any healthy, objective and legitimate criticism of institutional functioning of the judiciary. So, if the judiciary, like any other institution, is suffering some deficiencies, and if an expert committee highlights such deficiencies, it will be a welcome step not only for the future generation of this nation, including the judges and practitioners, including the future judges and practitioners, it will open avenue for the present stakeholders to take necessary remedial steps, correctional steps. Correctional steps. Next paragraph. It shall be appreciated if the committee of domain experts to be constituted by the Government of India within 1 week, also associates the National Judicial Academy, Bhopal, for the purpose of highlighting curriculum of not only class 8 but the higher classes also, for which the curriculum is finalized by NCERT.
On the question of judiciary, my lord, because there may be many subjects, my lord, with which Judicial Academy may not be concerned.
Legal studies. Legal studies. Legal studies.
Yes, my lord.
Legal studies. Mr. Solicitor.
Yes, my lord. I am grateful.
Next paragraph. After the order dated 26 February 2026 was passed, some elements in the so-called social media have acted and reacted irresponsibly. We firmly believe in catching the bull by horn. We accordingly direct the Government of India to identify such sites, the persons behind running those sites, and furnish their full details to enable us to take suitable action. Suitable action. The law must take its own course against mischief mongers.
Yes, my lord.
No one will be spared. Post this matter for further consideration also on date.
My lord, only now not on the subject, my lord, on this social media, my lord, I read something beautiful that we used to learn, my lord, Newton's law, that for every action there is an equal and opposite reaction. Now the next law is for every action there is a disproportionate and idiotic overreaction of social media. Only thing you need is a smartphone, a free Wi-Fi, and lots of time at your disposal. Then everyone has.
Our concern is, that's why our concern is only on misinformation.
Absolutely, my lord. Absolutely. It's
service to the society, we have no difficulty.
most abused medium of communication, my lords. I am grateful, my lords.
This matter.
Lords, the difficulty is that today wisdom has been sacrificed for gossip. That's all that is being transmitted on social media. And they don't stop short of pointing fingers at anybody. Nothing is sacred.
Mr. Madhul, what the bar is doing?
Lords, I can assure your lordships that the bar will correct
Don't
itself.
have to become party to these proceedings, want to arrange on NCRT, what are they doing about them?
I completely see what what is falling from your.
Yes, sir, even if they are hiding outside this country, I will not spare them.
Please, my lord.
I'm sitting here.
Please, my lord, we get the message clear, loud and clear, my lords. Grateful, my lord.
Grateful, my lords.
I am in 4086 and 4088. So a short question is whether the persons who are nominated as members of a municipal council or a town panchayat have a right to vote in the election to legislative council from local authorities constituency. This is in short the questions. So the facts are in very narrow compass. The petitioner before your lordship is an elected candidate from local authorities constituency.
Elected to state legislative council.
Please, your lordships.
Yes.
Elected to state legislative council, not to the municipal corporate.
No, legislative council.
Legislative council.
Lordships are right.
Now, after the elections, the contesting respondent filed a writ petition in the High Court on the ground that the persons who are nominated as members of the municipal council or town panchayat, their names are included in the voters list. And since their names are illegally entered in the voters list, the petition should be allowed. This is in short what, and that found favor with the High Court, and that's how I am before your lordship. Now my first proposition is that the Constitution makes detailed provisions relating to nominating persons to legislative bodies, the voting rights, and the restrictions on voting rights. Now we are principally concerned with Article 243 R2, but this is not a standalone provision. 243 R2. But I will take your lordship through. This is not a standalone provision. There are several other provisions in the Constitution which deal with nominating persons as members of the legislative bodies, the voting rights, and restrictions on voting rights. So I take your lordship first to Article 80.
Where you have to go in?
Article 80 of Constitution.
Actually, it is straight to the start. Which one?
So kindly turn to Article 80, Clause 1, Subclause A. 12 members to be nominated by the President in accordance with the provisions of law.
It pertains to Parliament, right?
Yes, Rajya Sabha. And if your lordships turn to Article 331 and 333.
So 80 which clause is pointed out, Mr. Abdul?
So 80.
But the 80 entire pertains to.
Article 80, Clause 1, Subclause A. 12 members to be nominated.
All right.
Then your lordship may come to Article 331. Notwithstanding anything in Article 21, the President may.
Article?
331. Though this has now virtually become defunct, but still it exists in the Constitution. Notwithstanding anything in Article 81, which deals with Lok Sabha, the President may, if he is of the opinion that the Anglo-Indian community is not adequately represented in the House of the People, nominate not more than 2 members of that community to the House of the People. Then Article 333, which deals with state assemblies, identical provision. Notwithstanding anything in Article 170, the governor of a state may, if he is of the opinion that the Anglo-Indian community needs representation in the legislative assembly of the state and is not adequately represented therein, nominate 1 or 2 of that community. So the first point is that nomination is something which is there in the Constitution. In that context, now your lordship will come to Article 170, 138. With which we are directly concerned.
One?
171, Clause 3,
Compulsion of the legislative council.
Clause 3, Subclause E. Of the total member of the Legislative Council of a state, then your lordship may come to Subclause E. The remainder shall be nominated by the governor in accordance with the provisions of Clause 5.
Show A.
Yeah.
So mainly we are, the issue before us is of 171.
171,
3A.
3A. Your lordship may see A. As nearly as may be 1/3 shall be elected by electorate consisting of members of the municipality, that is the local authorities constituency.
And 243.
Members.
So therefore your lordship will see legislative council consists of elected members and nominated members. We saw that provision in also in case of Lok Sabha, Rajya Sabha. Now this has some decisive significance. Now your lordship will come to Article 243. R. Same as provided in clause 2, all this,
Yes.
all the seats in the municipality can be filled by persons chosen by direct election from the territorial constituencies in the municipal area, and for this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. Then the legislature of the state may by law provide representation of the municipality, persons having special knowledge or experience in municipal administration, then etc. Then your topic will come to the proviso. Everything hinges on Article 243 to this proviso. Provided that the persons referred to in paragraph 1 shall not have the right to vote in the meeting of the municipality. So mark the words, in the meeting of the municipality. That this has nothing to do with election to legislative council.
You are reading which?
So proviso Article 243R to the legislature of a state may by law provide for representation.
Provided that, that's.
Your Lordship got it?
Yes, yes.
And kindly see the proviso. These are nominated persons. And proviso says that the persons referred to in paragraph 1 cannot have a right to vote in the meeting of the municipality. Now my submission is going to be that the Constitution deals with nomination, it also deals with voting rights, and also deals with restrictions on voting rights, which I will demonstrate to your Lordship from several other provisions. Your Lordship may then come to Article 92, Clause 2.
Yes.
This relates to the chairman of the Rajya Sabha. The chairman shall have a right to speak and otherwise take part in the proceedings of the Council of State, while any resolution for the removal of the Vice President from his office is under consideration. But notwithstanding anything in Article 100, cannot be entitled to vote at all on such resolution or any other matter during such proceedings. Then your Lordship will come to Article 96(2).
Yes, yes.
The Speaker shall have a right to speak in and otherwise take part in the proceedings of the House of the People, while any resolution for his removal from office is under consideration in the House, and shall, notwithstanding anything in Article 100, be entitled to vote only in the first instance on such resolution or any other matter during such proceeding, but not in the case of an equality of votes. The point which I want to emphasize is that the Constitution specifically deals with the right to vote and a right and a restrictions on that right.
Your argument is that different expressions
Correct.
and different,
Your Lordship, sir, correctly pointed out what I am.
in order to draw a distinction between where they wanted to prevent right to vote.
And a restriction on the right to vote. Now kindly see Article 100. Same as otherwise provided in this Constitution, all questions at any sitting of either House or joint sitting of the Houses shall be determined by a majority of votes of the members. Kindly see, my lord, members present and voting other than the Speaker or a person acting as chairman or Speaker. Now, the expression used is member. It is not with a qualification that only elected members. Similarly, your Lordship will find an identical provision in state legislature, which is Article 181.
Yes.
Clause 2, identical. The speaker shall have a right to speak in identically worded with 96(2). I need not trouble your lordship. Then kindly see 185. Clause 2, identically worded. The chairman shall have a right to speak, etc. This relates to the legislative council. Then your lordship will come to Article 189. Identically worded with Article 100. Now, sir, kindly come to Article 54.
5-4.
Yes.
President's election. The president shall be elected by the members of an electoral college consisting of elected members of both houses of parliament. The nominated persons are out. The elected members of the legislative assemblies of the state. So the nominated members of the Rajya Sabha also have a right to vote. But for Article 54. So Article 54 specifically says nominated persons have no right to vote, only elected members. So the point which I am making is that whenever a voting right is denied, there is a specific provision. Now kindly come to Article 84.
66 immediately vice
Yeah.
president nominated member
Yeah.
can vote. 66
So kindly come to 66
for a vice president.
for vice president.
Is member not elected.
Yeah.
President is different, vice president is
Identical provision with president.
different with election.
Yeah. I list out Article 66. Kindly Article 66 which deals with vice president. The vice president shall be elected by members of the electoral college consisting of members of both the houses of parliament in accordance with
Not elected.
proportional representation by means of the single transfer of vote and voting rights at such election shall be held by secret ballot. Now here your lordship will find there is an absence of reference to nominated members.
Elected.
I'm sorry, elected members. So which would include the nominated members
Second.
also. Now, then your lordship will come to Article 80, Clause 4. The representatives of each state in the Council of State shall be elected by elected members of the Legislative Assembly.
The 80 sub article 4.
So 80 sub article clause 4.
Yes.
The representatives of the state in the Council of State shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system. So the point is that the Constitution specifically deals with elected members, nominated members. Sometimes voting right is given even to nominated members, sometimes it is not given. Now, kindly come back to Article 171, 3A for a minute.
Yes.
Of the total number of the Legislative Council, as nearly as may be, 1/3 shall be elected by electorate consisting of members of the municipality
Not elected.
and not confined to elected members. Article 171 itself contains two types of membership. Elected.
So here that elected is conspicuously missing according.
Yes.
But
So therefore, your lordship feels that the High Court has misdirected itself in saying that Article 243 R2 proviso takes away right to vote in a meeting of a municipality is also equivalent to right to vote in an election to the legislative council. This is the basic error. This is the main point, my lord. Now I take your lordship to I have shown to your lordship Article 171(3)(a). Now brief submission is that there is a clear distinction between a nominated member and an elected member. Now what the High Court has done, that because Article 243(2)(a) proviso says they have no right to vote in a meeting of a municipality, they have no right to vote in an election to the legislative council. Now obviously an election to the legislative council is not a meeting of the municipality. Then I will show to your lordship the judgments on which the High Court has relied. Every single judgment arises out of voting in a municipal meeting.
Election.
Yes. Now before that, I must invite your lordship's attention to the fact.
your next argument is, the second contention is that when the members of the municipal council votes for the election of legislative council, it is not a meeting of the municipal council.
Correct.
This is what the
That's the sum and substance, my lord. But there is something more to garnish my argument. I will take your lordship to Article 171(2) for a minute. Until the Parliament by law otherwise provides, the composition of the Legislative Council of the State shall be as provided in clause 3. Now we will see what is the law enacted by the Parliament. That is the 1950 Act, Representation of People's Act. Now, if your lordships look at the part 4 of the 1950 Act, so probably your lordships do not have 1950 Act.
no one can just start in.
Yes, my lord, I will get you.
Do we have representation? Okay.
We have the copies there.
Yes, again. 1950. Maybe.
Our mistake, we did not turn.
Why does it come up?
They have. It has both in one. 27.
27.
What?
You have a spare copy.
We have one copy, sir. We have.
So kindly come to part 4 of the 1950 Act, which begins with 26, which is now deleted.
Same book. Or it may be at page 21, my lords, since your lordships are holding the same book. Section 27.
That code starts from section 26.
Yes, it starts with 26, which is deleted now. Whether is lordship
Yes,
gets the contrary got?
Will my lords have
All
all of them?
In this section, local authorities constituency, graduate constituency and teachers constituting name a constituency for the purpose of election to a legislative council under subclause A, subclause B and subclause C respectively of clause 3 of Article 171. For the purpose of election to the legislative council of a state in any local authority's constituency, the electorate shall consist of members of such local authority, exercising jurisdiction in any place, so also. Then B, every member of each such local authority within a local authority's constituency shall be entitled to be registered in the state, to be registered in the electoral roll for that constituency. Shall be entitled to be registered. Now, kindly see me lot E for a minute. The provisions of sections 15, 16, 18, 22 and 23 shall apply in relation to local authorities constituency as they apply in relation to assembly constituencies. So these sections fall in part 3. The entire part 3 of the 1950 Act does not apply, but these provisions apply. Now I want your lordship to have a look at those provisions. So here also in section 27 also makes no distinction between a nominated member and a elected member.
Constitution 27A, capital
Yeah,
A.
yeah.
It uses elected. Same act was used. 27 capital.
Yeah. So kindly have a look at 27A also in this concept.
Capital A,
27 capital A.
sub clause 3 and sub clause 3 and
Yeah.
4.
Yes. Subsection 3. The electoral college for the Union Territory of Delhi shall consist of elected members of the Legislative Assembly constituted for that territory under the government of Control. The 4. Electoral college for the Union Territory of Pondicherry shall consist of elected members of the Legislative Assembly. Now, therefore, the part 4 itself refers to elected members and member simpliciter. Now, member simpliciter would include both elected as well as nominated. Now, sir, kindly come back to preparation of the voters list.
Section
Now, that for that purpose, we will have to go back to 15, 16, 18, 20, 22 and of part 3.
Preparation 21, sir.
Yeah, but no, 22. 22, 21 does not apply. So your lordship will come to 22,
part 3.
section 22. 21 doesn't apply. If the electoral registration officer for a constituency of an application made to him or on his own motion is satisfied after such inquiry as it thinks fit that any entry in the electoral roll of a constituency is erroneous, defective or any particular should be transposed to another place, etc., etc. So this is correcting an entry. Then kindly come to 23.
23.
Any person whose name is not included in the electoral roll of a constituency may apply to the electoral registration officer for inclusion of his name. Now, curiously enough, section 24 doesn't apply to part 4. In other words, the indication is that once the electoral roll is prepared, it acquires finality. Now, kindly see me, Lord.
Roll has never been changed. Electoral roll has never been changed.
Now, I will take your lordship to another point. So, the High Court has relied upon principally on the judgment of your Lordship's court in Shelley's case. Oberoi Shelley. That is reported in 2023 5 SCC page 414.
365 company.
So there is a short comparison of judgments.
Yes.
I take your Lordship to page 65 of that compilation.
65 is Shelley Oberoi.
Yes, Shelley Oberoi. Because that's the main judgment on which the High Court has relied. Take a copy. So kindly come to para 2 on page 66. Chapter 2 of the Delhi Municipal Corporation Act 1957 deals with the establishment of a corporation. Section 35(1) provides that a corporation shall at its first meeting in each year elect one of its members to be the chairperson, who is known as the mayor, and another member to be deputy mayor of the corporation. Section 3 provides for the establishment of the municipal corporation. Subsection 3 of section 3 indicates the composition of the corporation. In terms of the provision, a corporation is to be composed of councillors, bodies of the councillors who are directly elected through the voters in the ward constituency. There are other councillors who are nominated by the administrator. Now kindly see section 3(3)(b) which is quoted there. 10 persons who are not less than 25 years of age and who have special knowledge or experience in municipal administration to be nominated by the administrator. The proviso to section 3(3)(b), however, lays down that the persons nominated under this subclause shall not have a right to vote in the meeting of the corporation. This does not deal with voting through a legislative council. Now kindly see para 3. Chapter 3 of the Act deals with the procedure and the transaction of business by a corporation. Section 72(1) provides that a corporation shall ordinarily hold at least one meeting in every month for the transaction of business. Section 73 provides that the first meeting of a corporation after a general election shall be held as early as possible after the publication of the results of the election under section 14 and shall be convened by the administrator. Section 76(1) stipulates that a mayor or in his absence a deputy mayor shall preside over every meeting of the corporation. Section 77 makes provision for presiding officer at a meeting for the election of a mayor. Clause E of section 77 provides that a meeting of the election to the mayor to the administrator shall nominate a councillor who is not a candidate for the election preside over the meeting. Section 78 provides the method of deciding the common questions. Then kindly 4. Though the jurisdiction of the court has been invoked for seeking several reliefs, the point of controversy has narrowed down to 2 issues. First issue is whether the aldermen, that is the nominated persons, as they are popularly described, who are nominated by the administrator under section 3(3)(b)(1) have a right to vote at the first meeting of the corporation where the mayor would be elected. So this was the controversy. Then kindly come to para 11. Then your lordships have reproduced article 243R. Now kindly come to section para 8. Section 3(3) of the Act is the law contemplated by Article 243R in terms of clause 2 of Article 243. Section 3(3)(b) provides for the representation in the municipal council of persons who have special knowledge or experience in the municipal administration. These persons are nominated by the administrator. However, in terms of the proviso to Article 243R2, a similar restriction is introduced in the proviso to section 33B of the Act, by which the nominated members do not have a right to vote in the meeting of the municipal corporation. Then your lordship will come straight to the contentions of the parties. Dr. Singhvi argued
But 11 will be relevant.
paragraph 11 is the ratio. We are unable to accept the submission which has been urged on behalf of the municipal corporation and the Lieutenant Governor and by the council supporting them. Yeah. So we can straight away go to the Constitution and the Act places
From the bottom.
almost at the bottom. The provisions indicate that the persons who are nominated members under subclause shall not have a right to vote in the meeting of the corporation. Your lordship got that? So that's the ratio. Then kindly see further, the meeting of the corporation would include all meetings, including the first meeting, which is held after the holding of the general election. Section 73 of the Act provides for the first meeting to be convened, so that provisions we have seen for the purpose of electing a mayor. So this judgment on which the High Court has relied is principally deals with voting right in the meeting of the municipality. It has nothing to do with election to the Legislative Council. Then similar view is taken in Ramesh Mehta, that your lordship will find at page 106, 126. Identical. This arises out of Rajasthan law. That is the only difference. And I can straight away take your lordship, show to your lordship. Article 243R is quoted in para 6 and then para 10. And then paragraph 11, etc. The same propositions as are laid down in Shelley's case. Now there are other judgments which are, I find it very curious how the High Court was persuaded to look into those judgments. They have nothing to do with the issue which was before the court. So take People's Union for Civil Liberties, that is reported in 2003 for SCC 399. I don't wish to trouble your lordship with this judgment. It deals with constitutional validity of section 33B. Your lordships are aware of the legislative history. This has nothing to do with voting right in a legislative council or even in a meeting of a municipal body. Then State of UP versus Kartar Singh's AR 64-1135. This judgment deals with food adulteration. I wonder how High Court could make even a passing reference to such a judgment. Then the next judgment which is referred to is Jaira Singh versus State of Rajasthan, AR 1975 Supreme Court 1436. This judgment deals with Colonization Act of Rajasthan 1954, again nothing to do with. Then State of Haryana versus State of Punjab 2004 12 SCC. This deals with rejection of a plaint. Again then Ramesh Mehta, I already indicated to your lordship, it follows the same line. Then the Karnataka High Court judgment itself, this judgment also deals with, both the judgments, Karnataka judgment deal with election, not with the election to the Legislative Council, but voting in the municipal meetings. So therefore, all the judgments to which the learned judges have referred to have nothing to do with the controversy. Now there is one more aspect. So if your lordships look at the 7th schedule, as far as elections are concerned, whether to the Parliament, Legislative Assembly or Legislative Council, the entire field is occupied by Parliament. List 1. Your lordship will come to that union list I'll give entry 72, sir. Elections to Parliament, to the legislature of states, and to the office of the President, Vice President, Election Commission, etc. So therefore, election to Legislative Council is dealt with by Constitution, Article 171, and in terms of Article 171(2), the Parliament has enacted a law, that is 1950 Act, to which I already invited your Lordship's attention. Now the state law has nothing to do with, except for a limited purpose, that the state law in terms of Article 243R also provides for nominating members. Beyond that, it has nothing to do. Now, one fundamental error which the High Court has committed is, if your Lordships turn to page 68 of the judgment. It refers to section 2 into bracket 6. Paragraph 22, if your Lordship. Towards the end of that para, it is also the contention of the learned counsel that the term councillors has been defined in section 2(6) of the Act of 1964. That is the Municipalities Act of 1964 enacted by Karnataka. As any person who is legally a member of the municipal council. So the definition is quoted at page, it is quoted on page 54. If your Lordships turn to page 54.
I know you have to refer to 45.3, your Lordships. I think your Lordships have the first criteria. 45.
Para number.
Please refer to the paragraphs.
21. Section 26.
So, no, not para 21. It is, I can't remember, 17 probably. It's a very long para.
45.3.
Your Lordship got that para? That
352 of the Karnataka Municipal.
para 17 and it should be page 54 in my SLP.
Internal page.
Internal page 52. Internal page 52, para 17.2. Space, para starts with point 2.
Page 54.
Page 52.
Your Lordship got that? Kindly see, the councillor means any person who is legally a member of a municipal council or a town panchayat. Now this expression is construed by the High Court. Your Lordships have not seen this. I must go to
Page 309 of the lead, man.
If a legal member of the council means that he has been lawfully made member of the council.
my lord.
And your argument is nomination is one of the prescribed legally authorized mode of.
Yeah. Now the definition of, even in the Municipal Act, Karnataka Municipal Act, a councillor means any person who is legally a member of a municipal council or a town panchayat. It does not say elected. Now the High Court construes this as elected member. Now this is adding words, which is not permissible. Your Lordship will find that in paragraph 68 and 69. Sorry, paragraphs 22 and 23 at page 68 and 69, which is the
45.3.
page of the
Page
68.
lead 5.
Page 323 and 324. Now this is adding words. Now therefore, it's sum and substance. So there is a one still small one point. If your Lordship permits me to come.
Yes, you could. Yes, we can wait for time.
Yeah.
We are almost concluded, Mr.
Yeah.
We have understood.
Now, the last point is that the electoral roll is published. I just give to your lordship the relevant dates for a minute.
Draft list on 11th November.
I just give to your lordship dates.
11th November.
Give me the. So the draft was published on
11th November.
11th November 21.
Final list.
And the final list was published on 23rd of November 21.
And the election was when?
Election was held on 10th of December 21.
Results on 14th December.
And the results were declared on 14th December 21, and thereafter this petition was filed in the High Court. At no point of time
The voter list, final voter list was changed.
final vote. Now there is a judgment of your lordship court, and fortunately for me, it's a judgment of a constitution bench, which says that somebody's name is wrongly included in the voters list. Cannot be a ground to file even an election petition under section 100. That is final. Now, but I must say that that matter did not directly arise out of legislative council election from the local authorities constitution. So I just give to your lordship.
Page 21 of the company.
It is page 21 of the compilation.
Shamdev Singh.
That is 2000 volume 8 SCC page 46 and the para 26.
Yes.
In terms says, para 26 will not on page of that compilation.
Page 20.
The page. Para 26.
It's under page 21.
Right, starts at page, and if your lordship come to
Entire page 21.
para page 35. To sum up,
Yes, to
opinion that inclusion of person or persons in the electoral roll by any authority empowered in law to prepare the electoral roll, though they were not qualified to be so enrolled, cannot be a ground for setting aside an election of a required candidate, written candidate under subclauses 3 or 4 of clause D of subsection 1 of section 100. This is finality. Now therefore in my respectful submission, and that too after the elections, this petition was clearly misconceived. I am grateful, Madam.
Thank you, Mr. Officer.
So my learned friend who is appearing in another matter.
Concluded that everything is covered.
I think
Everything is
Doctor
covered.
is very elaborate.
Only, two cases came to be filed. One was a writ petition, one was an election petition. Election petition is covered by this 3-judge bench. There are 2 constitution bench judgments which affirm the same principle. That once the election is concluded, on the ground of defect of electoral rolls, you cannot file an election petition and succeed. In the writ petition that they filed, they specifically asserted because election petition remedy is not available to us, we are invoking the writ jurisdiction. Article 329B specifically says no election will be called in question, and your lordships have held this applies to writ petitions also, only election petition to be filed. While it is a continuing process, but if they don't succeed on merits, everything goes. Even if they succeed on merits, your lordships have held the revision and correction of the electoral roll will only endure for the future elections, not for the election which has already gone past.
So there is one more small aspect. The High Court goes into the question whether a writ petition is maintainable or not, and it refers to several judgments. It's undoubtedly a fact that maintainability of a writ petition is a matter of discretion, but not when it concerns the election petitions. That is, as far as Article 329 is the constitutional bar. The judgments which have been referred to by the High Court, they do not deal with the bar under Article 329. That's my submission.
One significant aspect, Election Commission is a party before your lordships. 1997, they issue a circular, stating that nominated members are a part of electoral rolls.
Election Commission before the High Court files a counter affidavit and says they are a part of electoral rolls. We have consistently been practicing. The petitioner who files the case in the High Court, my lord, admits in his cross-examination in the election petition that yes, in the previous round also nominated members were there. I participated. I did not object even for the previous round.
No, sir, one factual addition is that the election petition is still pending before the High Court.
You can give a small note of if you want to give.
Just one proposition, right?
May I give a note within 3 days, what?
We'll do that minutes. 3 days. Just one proposition, because your lordships have said representative democracy is part of basic structure. The constitutional structure is representative democracy is inclusive of both elected members, nominated members. Wherever there is a constitutional bar on elected members, nominated members from voting in certain proceedings, the text is explicit. You cannot add to that, you cannot decrease to that. So let's say it is not as if the nominated members are not part of this representative democracy.
All of you can give a combined 2, 3, 4 pages of whatever means that. Where all of these submissions can, we come up to lunch.
Very well.
with the benign permission of your honor, serial number 26, which is on board, can it be taken up next week if it's not in?
No, we are sitting till 4:30.
Please unmute Mohit Paul, Mr. Mohit Paul for this mentioning, sir. Your Lordship.
So, please.
I'm in that matter, I'm partnered.
Oh, no.
Yeah, sorry.
Dear Lordship, right?
41, the judge.
We all came here for the 2 o'clock.
Sorry.
No, we are now continuing partnered. I'll finish in 15-20 minutes.
The judge's case, Lord, item 41 was.
We are confident you will finish in 10 minutes.
20 minutes, then maybe a little misleading your lordships, but I'll just, the case law will take time. Let me hear lordship the point form now.
Lord, item 41 was the judge's case, which was fixed at 2 o'clock. Would your Lordship be taking it up now or after this item 45, Lord?
We'll take some matters out of 10, which are presumably are important matters. We'll take up including this matter, which you are referring to.
Lordship, please.
We'll definitely try to take up.
Lord, I beg to appeal for the Election Commission in this matter which is going on. Would your Lordships permit me to make submissions ahead of Dr. Singhvi?
I would like
or
to.
after, my Lord, I have no problem.
Then let me finish. I'll finish 15.
10 minutes to Dr. Singhvi, 5 minutes to
Yes.
Giri.
Union has been called upon because of the issue involved.
Mr.
I thought
That,
if
what is
Dr.
2
Singhvi
minutes
wants-
to Monaji, she is also there. So 10, 5 and plus 5, 20 minutes total.
Now, Mellis,
No, not that
the issue is,
my submissions are also, my submissions in concerns with the submissions that I made before the High Court. It will probably Dr. Singhvi would want to reply to that also. That's why it's.
allow me to.
But otherwise, if he wants to complete.
Yeah, very good. I'm grateful. Now, Mellis, let me be very quick. Your lordship has given me 10, I'm requesting 15 at least. I'll be very fast, Mellis. And my time should start now, Mellis. Not from earlier. Now, Mellis. Please note, this is admitted facts. 12 nominated panchayat councillors voted in the upper house election of Karnataka. I'll make it very simple. My lordship knows the case now.
Well nominated.
Yes. I lost by 6 votes. 1182 versus 1188. The admitted facts.
You are R1,
I am R1.
lost by 6 votes.
Yes. Learned single judge allows my writ to exclude from the voters list those 12. The writ is, they are wrongly on the 12, exclude them. The learned division bench affirms, I have concurrent in my favor. This process and the pendency here eats up 4 out of the 6 years of the term. So the other man is in Sizen for 4 years now.
4 out of 6 are over.
4 out of 6, right? 4 out of 6 is over. My lord remembers in the old days, my lords of the bar must have done that provision. It is 1950 provision. It shall be endeavoured that election petition is held in 6 months. Your lordship would know those. In those days, you should have one judge sitting in the afternoon doing election. Even then, they were doing it in 6 months. Now, your lordship never has 6 months. Anyway, that's by the way. Now, Malas, the issue is very interesting and very, very small. And there is an absurd consequence if they are held to be right. Let me tell you why. The issue is whether nominated councillors who are prohibited under, this case also involves councillors, nominated councillors who are prohibited under a constitutional article 245R, capital R, from voting in their own municipalities or panchayats.
Yes.
Can be allowed or held to be entitled to vote as voters in the upper house election.
Yes.
So look at the absurdity, Malas. I am prohibited specifically not to vote in my own house. So Shelley Oberoi, where I had the privilege of assisting the court, was a case where these nominated councillors in Delhi voted for their own mayor. The court held that you are prohibited, you can't do it. But your lordship should hold that the same person who can't vote here can vote in the upper house. Why? Because there is no specific thing writing that for the upper house you can't vote. That's the only argument.
That leads to an absurdity which is covered by at least 3 judgments of the Supreme Court and 2 of the High Court. Shelley Oberoi is one, I'll be reading it. It relies on Ramesh Mehta, which is very important. And then there are 2 others High Court.
Rajasthan matter.
I beg pardon?
Rajasthan matter.
Rajasthan matter, correct.
Just to correct.
It's a covered matter according to me. I don't want to exaggerate, but according to me it's covered. And yet on a covered matter they've taken 4 or 6 years. Now, and the other 2 are High Court, Savitri and Chandubai. Now, the other, I'll be elaborating in a minute. The other point is why writ? My lords, in a Karnataka High Court matter where Mr. Jethmalani was the respondent, the person fighting the election, said that the correct thing is that if you are saying, that you are wrongly included in the voters list, you have to go in a writ and also file an election petition. First, get the writ decided in your favor, produce that order to the election petition court, in those days it used to be tribunal, and then they will pass the order keeping in light what the writ court has held. Exactly the same has happened here. I filed 2 things. How can I be faulted? I filed a writ and an EP. For a while, the EP was kept in abeyance. The writ court decided, same Karnataka High Court. And following that and relying on that, the EP is decided in my favor. Now on these facts, just see 3 or 4 things. First, turn to 171 and 243R. Please give the Constitution. Of the Constitution. So 171 of the Constitution
Yes, compulsion of legislative council.
Now your Lordship is considering the upper house of a state. Many states don't have it, but the states which have it.
Legislative council.
Yes, which is the upper house of a state, legislative council. Page 2, clause 3. This is 171 bracket 3. This is Bakshi has got it. Of the total number of members of the legislative council of a state, A, I am interested only in A, as nearly as may be, 1/3 shall be elected by electorates consisting of members of municipalities, mark this verse, district boards and such other local authorities in the state as parliament by law specify. My lord knows this. For the upper house in the state, you have designated quotas of constituencies. Some teachers constituencies, some municipalities. But the word here is important. Electorates consisting of members of the municipalities. Now come to 243 which says that these electorates can't vote in the municipality. By a small process of interpretation, your lordship should not hold that under 171(3) they cannot vote in the upper house. Now turn to 243R. So, 171, which refers to municipality, takes you by word, or town panchayats or local, whatever, all are covered, all are covered, to 243R. Save as provided in clause 2, all the seats in a municipality shall be filled by persons chosen by a direct election from the territorial constituency in the municipal area. And for this purpose, each municipal area shall be divided. I'm interested in 2, Malas. I'm interested in 2. The legislature of a state may by law provide for the representation in a municipality of these people, Malas, persons having special knowledge or experience, members of the House of People and the members of the Legislative Assembly representing constituencies comprise wholly, members of Council of States and members of Legislative Council, chairpersons. Then they pluck out one clause, the first one. Why, Malas? Why is one clause plucked out? Please ask yourself that question. Provided that the persons referred to in para 1 shall not have the right to vote in the meetings of municipality. Because Malas, you are nominating people of skill, etc.
Well, the rest are presumed to be elected.
The next one also, Malas. The manner of provided B is for the manner of election of the chairperson also of a municipality. So for these things, all can vote, but I can't vote. I meaning small I, small Roman I. That is, Malas, persons having special knowledge. Because what happens, Malas, these nominations are made by the government. As it happened in this case, Malas. The previous government nominated these people. When the time came for election to the upper house, the pre-nominated people, all en masse, these 12 of them voted against. These were people who were nominated for their skill elements. For example, of course, there's one word there different. For election of the President of India, election, all of us MPs can vote once. But the nominated MPs can't vote. But there, the answer of their side will be that there is a word elected there. Here, your Lordship has to do that small interpretation that you can't vote in your own municipality. How can you be allowed to vote? What is the value of your vote if you can't vote in your own municipality? Now, let us turn to the judgment. Turn to Sherry Oberoi. According to me, it covers fully. Can you take the one your Lordship has marked? No, but my Lord has marked it already in the pre-lunch period. You take that. 300 judges of the Lordship's court very recently. So, because Sherry Oberoi is given to your Lordships in the compilation.
You are referring to Shelly?
I think 65 of what he gave us.
Which one are you referring?
60, serial number in his compilation 7, page is 65.
Page 65.
So, Shelly
Yes.
Yes.
Now just see 4 or 5 paras, but very quickly. The jurisdiction of this court under 32 has been invoked for seeking diverse reliefs pertaining to the constitution of the municipal corporation following the elections which took place in December 22. These elections were held to elect 250 councillors. The first petitioner is a prospective candidate for post of mayor. Right, Wallace? There was a second issue rising which Lordship is not concerned with. I am only on the first issue. Para 7. Clause 1 of 243R, so same article, stipulates that all seats in the municipality shall be filled by direct election held from territorial constituencies. An exception is provided in clause 2 in terms of which legislature of a state may by law provide for representation in a municipality of persons fulfilling the description set out in 1, 2, 3 and 4. Article 243(2)AI, that's the one your Lordship saw just now, I. Provides that the legislature of state may by law provide for the representation in a municipality of persons having special knowledge or experience in municipal administration. However, the proviso to clause 2 clearly specified that persons who are referred to in para 1 shall not have the right to vote in the municipality. The legislature of the state may also provide for the manner of election. Whereas last 2 lines of para 8, these 4 lines, these persons are nominated by the administrator in terms of proviso 2. A similar restriction is put in 3(3)(bi) by which nominated persons do not have the right. Then your Lordship will turn to para 11. Well, my submissions are in para 9 and then 11.
We are unable to accept this submission.
Middle of 11, we are unable to accept the submissions how the para starts after E. As already noted, the Constitution provides a direct election. Clause 2 contains provisions for representing the municipality of persons having special knowledge or experience, as well as the other persons such as members. Then G. G is important. There is a categorization made for such purposes between nominated and elected. The above provisions indicate that persons who are nominated shall not have the right to vote in the rights of in the meetings of the corporation. The Constitution and the Act place value on their experience, but the right to vote is not granted to them at the meeting of the corporation. The meeting of the corporation include all meetings, including the first meeting, which is held. 73 provides for the first meeting to be convened by the administrator as early as possible, while 35 provides for the election of mayor and deputy mayor at the first meeting. The prohibition on nominated members exercising the right to vote in terms of 3(3)(bi) shall therefore also apply to the first meeting at which the mayor and the deputy mayor are done. 13 affirms Ramesh, which my Lord said is from Rajasthan. Para 13. Now turn to Ramesh in the same compilation. Ramesh is the old established judgment, which they were affirming. 106 of that same compilation. Sorry, 160. 106 of my Lord's.
Yes.
In this, please turn to para 1. For a 3-judge bench, Justice Kapadia speaking, the question raised is whether in counting the whole number of members of the municipal board.
110.
Para 1, first para.
Yes.
The issue is summarized and encapsulated. The question raised in this whether the counting the whole number of members of the board in terms of 3(9) of the Rajasthan motion, nominated members have to be taken into. So the phrase there was whole number of members of the municipal board. On that, come to para 8. Just note para 6 for 30 seconds, Malas. 243R is fully dealt with in para 6. Para numbers are matching. Para is the same. No? Para is the same, Malas. Now see, Malas, para 8. The question involved in the present civil appeal is whether nominated members in a board are to be counted for calculating the majority required for carrying a no confidence against the chairman. You can't touch your own municipality, but you can vote to the Rajya Sabha, the upper house. The absurd conclusion, Malas. Now let us kindly turn to the end of last 3 lines of para 9. Last 3 lines. I am only doing some speed reading to save time, the relevant part only. We are therefore of the view that even prior to 94, the words whole number of members under Rule 3 meant total number of members who have voting rights. My lord has got it? Last 3 lines of para 9. Then, Malas, 11. In the present, the second half of 10 also is there, but I will not read it. 11. In the present case on facts, we are concerned with the post-94 position. 243R brought about a drastic change in the matter of composition of municipalities. They have inserted a constitutional proviso. It lays down guidelines with regard to the constitution, composition, election and rights. Under the Act, members of municipality are persons chosen by direct election in a ward. 2AI allows the legislature of a state to appoint any person who has special knowledge in the field. So it's a pure nomination. However, proviso appointed precludes such nominated persons from having a right to vote. The constitution, kindly mark this, Malas, G, 2 lines below G. This is the principle of law. Why, Malas, a bench of 3 learned judges. The constitution therefore makes a distinction between elected members and nominated members who play essentially an advisory role. Pursuant to the 74th, etc. Then, Malas, para 13 to sum up. Para 13 to sum up. Justice Sinha in a concurrence, just look at one para, Malas. Para 41 at the very end, last, is concurring, Malas. The decisions of the courts as regards the right of participation of the member who is an elected member or who had a right equal to that of an elected member has been taken notice of by Brother Kapadia J. The said decisions are pointers to the fact that only elected members and those who are to be treated at par were entitled to participate in proceeding, etc. Now, Malas, I will not read to save time. To the same effect are 2 important High Court judgments. In your Lordship's book also it is there. Savitri? No. Well, just take my compilation, only take it, don't read it. Kindly give my compilation. Savitri and Chandubai, which the impugned orders follow concurrently in my favor. Kindly give this. Yes, kindly give it. Yeah, Maharaj? This one.
Already taken.
If you Lordship mark the index only, just Savitri is a division bench, Chandubai is a division bench. In my compilation, 10 and 11. Just tick it, Malas. Lordship wants to write the para in the index. Para 16 of Savitri, which follows para 9 of Chandubi. Chandubi. My Lord has got the last 2, Malas. The index. Same principle they are doing. Now, Malas, just to keep your Lordship's time limit, Malas. Just turn to that Karnataka judgment about filing a writ and an EP. And the EP should await the outcome of the writ. Turn to that. Turn to the judgment. Give it to them. It's here. Sorry if just one judgment we are giving such a fat compilation. Only one judgment is there is relevant. Give it to me. This is yours. 484 of this plump book, Malas. Called J. Robert versus Ram Jethmalani. 484. And today, Malas, both courts have held, and following the writ petition, which says you are wrongly included, a jurisdictional question is there, but just kindly give me 30 seconds. Jurisdictional question is you can't include this class of people. It's not about individual. The writ court decides you can't include. Once you can't include, 12 votes go. I have lost by 6 votes. The EP decides it. Why should your Lordships, Malas, supposedly, according to them, upset the law by not the simple interpretation that they cannot vote? Today, Malas, on a maintainability, they are also arguing maintainability. I have in fact done both. I have done more than necessary, not one. I have done both writ and EP. The writ court says these 12 inclusion is wrong. The EP court applies his own mind and says overall this is correct. I am also following it. If you exclude 12, 6 fellows doesn't matter then. Now let us kindly come to 484. Starts at 492. Justice Rama Joyce, as he then was, wrote a very detailed judgment, and I will not fellows read most.
Just saying there is no need to cite.
Very well. Just note the para, then I'll leave it. I'll not. He says, just see page 531. Just stick that, because otherwise I should have to search fellows. It says you first get it from the competent authority. Well, kindly mark the word. Competent authority means the election, well, it's the writ court. I'm sorry. First get it from the writ and then produce it before the competent authority. Competent authority is the election court. In those days, well, the Lordship used to have the competent authority. Now you have the election court doing it. Well, lastly, just turn to my, so that's 531. Now let's turn to my concurrent findings for a minute of the impugned order. Well, in these very well reasoned two orders, why should Lordship interfere is my question to myself. Please turn to volume 1. First turn to the learned single judge at 153 of the first volume. Look, there may be issues which everybody can find, but unless the Lordship find a miscarriage of justice or something perverse, I don't understand why concurrent findings should be interfered with. I may be wrong. 151, learned single judge starts at 141. In fact, it's a very long course title. Starts earlier, I'm sorry. It starts at 130. Right? The relevant parts will start from 153, para 13 onwards. Para 13, 153. Conjoint reading, page 153, para 13. Kindly hand over.
Yes.
A conjoint reading of the aforesaid provisions clearly indicates that section 24, which provides for an appeal against inclusion of names in the electoral roll of the assembly, is conspicuously absent in 27E of the RP Act in relation to inclusion of names in the electoral roll. So their argument is I should appeal. They say I should have appealed against the wrongful inclusion and not gone in a writ. So he's dealing with that. He says, well, section 24, which provides for an appeal, is conspicuously absent in section 27E of the RP Act. Hence, the provisions contained in the RP Act does not provide for a remedy of appeal to challenge the inclusion of names in the electoral rolls. I hope I got the last 4 lines of para 13. Direct finding. It is equally well settled that any illegality cannot be challenged in an election petition as held by the Supreme Court in the case of Kumar Nripendra Bahadur Singh. Right. Then, whereas the contention of the respondent is that the petitioner having chosen not to file objection to the inclusion of the names in the electoral roll, not having challenged at the earliest point of time, is not maintainable. Writ is not maintainable. Well, as he gives 4 reasons to save time, I'm not reading it, para 15. 4 reasons why writ is the only way out. And then he gives the finding at page 155. Then the learned judge Bellows at para 18 deals with this thing about nominated. He quotes 2.6, bottom of page 155, para 18. He does this small interpretation, means elected. It has to be elected, can't be nominated. That's all he's saying. And then he ends at 156 and 158 after quoting 243 and 171. What is so wrong or perverse in this? I would. In the division bench, which is concurrently in my favor, just 2 minutes more. Please come to page 42. It starts at page 1. Come to 42. The issues are very fairly, it's exhaustive judgment again, second time. Come to page 42. Issues are put at 42. Maintainability is decided by citing case law over 10 pages, 42 to 52. Same point. 10 pages. Then the findings start from page 52. And para 17.4 and 17.5 are important findings on 243R. And then all the remaining paras, that is 16 and 19, 20 are on Shelley Oberoi, Ramesh Mehta, Savitri and Chanubai. He quotes them all. Well, I would say it's a travesty of justice. They've already had a good run. The man has been voting. He has been getting the perks of office. There is no stay on his actual functioning. 4 years have gone. For a election void at inception, he's had a very good run. Please stop this run now, Malas.
Now we are deciding finally. Yes.
Here for the election, to avoid the repercussions as well as the election. I adopt the same submissions.
I'm deeply obliged.
Okay.
I haven't exceeded by much.
You can also give your whatever note you want to give in next 2-3 days.
Deeply obliged.
Is that the person who prepared the election?
Right, thank you, give the note.
I'll just take about 10 minutes, my lord. I'm not repeating the. Lord, we had filed a counter affidavit, my lord, in the High Court. We have filed a counter affidavit in the Supreme Court also. We have filed a note also, actually. The submissions are in sync with what the stand taken by the Election Commission before the High Court. My lord, we objected to the maintainability of the writ petition because according to us under 27, if there is the provisions under 15, 16, 18, 22 and 23 of the Representation of People's Act 1950 would apply in the case of 27, it has been made applicable as well. And therefore, my lord, if there is a challenge to the inclusion of names in electoral rolls, then my lord, instead of, even if section 24 has not been specifically mentioned in section 27E, doesn't matter because 23 is included and the appellate provision under section 24 is inserted, my lord, in the Representation of People's Act 1950 only in the year 1961, whereas 27E is inserted in the year 1956. That's 56, my lord. This is how it happened. My lord, it's on the, not only on the question of maintainability, just to keep the slate clear insofar as the statutory provision and the regime is concerned. This is one aspect of it. My lord, on the other, the stand that we took is this, my lord. 171 deals with, Article 171 deals with election to the legislative councils. It has been there, my lord, in the Constitution as far as I can see from the commencement. There has been some amendment, my lord, which was brought about in 1956 or so, but it doesn't really make any difference. My lord, 243 and 243R, Part 9A of the Constitution was enforced with effect from 1994. Now, my lord, insofar as 171 is concerned, it deals with the elections to the Legislative Council. And my lord, the manner in which elections to the Legislative Council will have to be conducted are governed by 171. 243 as such, my lord, deals with municipalities and 243R deals with, my lord, the elections to the municipal councils as such. There are two things, my lord, which I would respectfully bring to your lordship's notice and highlight. Now, my lord, one cannot construe, and this is, my lord, my respectful submission, one cannot construe 171 with reference to 243R or the statutory provisions, my lord, contained in enactment which has been framed under Article 243. My lord, there is no, my lord, the submission made by Dr. Singhvi that under 243R, there is a prohibition against the persons who have been nominated. There is a restriction on the nominated members in voting in the municipality meetings, and therefore, according to him, on a linear interpretation, why that restriction should apply in the case of 171 also. My lord, that will be difficult. 171 will have to be construed, and the electoral college in 171 will have to be determined on the basis of 171 itself. And 243, which has been inserted only in the year 1994, deals with municipalities and local authorities. And therefore, the restriction insofar as municipal meetings are concerned are restriction in municipal meetings itself. No doubt, my lord, the right to vote is not a fundamental right, but it is a right, my lord, which emanates either from the statutory provisions or, more importantly, the constitutional provisions itself. Therefore, my lord, when 171 speaks about the manner in which the electoral college for elections to the Legislative Council is to be constituted, to say that in that you should also juxtapose or dovetail Article 243 and the restriction contained in 243 into 171, my lord, would not be a process of interpretation which may come into your lordship's acceptance, my lord. This is my respectful submission. We have also challenged, my lord, the maintainability of the writ petition because according to us, that is quite important. Because every time, my lord, the elections are conducted, today it is on the inclusion of nominated members in the electoral roll. Tomorrow it could be something else. And therefore, my lord, it should confine itself to an election petition. It should not go to a writ petition. And my lord, inclusion of a person in the electoral roll, my lord, if it is to be objected to, and if the objections are not taken note of, there is a provision for an appeal under 224. And therefore, you will have to avail of that at that point of time. If you don't avail of it, no, my lord, then it is not possible to file a writ petition really challenging the election which has taken place after that. That's one aspect of it. That's one aspect of it, my lord. Now, apart from the question of maintainability, in my respectful submission, the provisions will have to be, your lordships will have to determine it, my lord, in the light of 171, in the light of 243, and my lord, in such a, whatever your lordships laid down, the election commission will have to follow. No, my lord, after the declaration, my lord, made by the Karnataka High Court, we have not included any nominated member, my lord, in the electoral roll for the purpose of any election that has been conducted later, subsequent thereto. No, my lord, subject to whatever law your lordships laid down, the election commission is bound to follow that. Until this happened, my lord, we were including it, and that is what has been challenged in this. My lord, one sentence regarding the two judgments. Shelley dealt with mayoral election in Delhi. Ramesh Mehta dealt with a no confidence motion, my lord, in a municipality in Rajasthan. They do not deal with 171. 171 has been dealt with only by the impugned judgment as such, in the impugned judgment. If the interpretation appeals to your lordships may lay down the law in that regard. Now, my lord, in my respectful submission, the question as to 171, whether it should be interpreted, taking into account the restriction in 243R also, is res integra insofar as your lordships are concerned.
Their argument is of a neutral umpire, Mr. Giri.
That's right.
Whatever the law earlier has been understood, you have followed.
Yes, sir.
Whatever way we now interpret, you will.
That's not what I am saying. Lord, my attempt is only to see that there is assistance rendered to your lordships, my lord, on behalf of the election. Insofar as and this is consistent with the stand that we have taken in the High Court also.
We like to tell your lordship.
And there was no, apparently, my lord,
he has not filed an appeal.
Sorry?
He has not challenged these orders.
I am not, I need not.
He is saying, Dr. Singhji, that he is
There
following
is
the
an
order.
affidavit that we will follow whatever the court says.
Rather, they are saying that after the High Court judgment, they have not allowed the nominated members to vote. Because as on date, that is the law. Now, whatever this court will lay down, of course, that will favor.
Well, on facts, there is one sentence which my learned friend.
There is no need of on facts for you to.
No, only that there was no objections to the draft voters list, electoral rule apparently.
That I will
This is also mentioned here. Great.
Yes, please.
Election Commission is a party to the writ petition. Writ petition was allowed against them. They did not file any writ appeal. Now they are pretending otherwise. How is it possible?
Yes, Mr. Giri.
I'm not getting into the facts because we are not interested.
They are also neutral umpire.
Yes, we are only on the interpretation of these provisions.
Sometimes you have to play the third umpire.
That's right. I prepared a short note on only on 2 points.
Okay.
The first issue is with regard to the right of the nominated members to vote, where I have drawn the comparison between various articles where the Constitution specifically wanted to give voting right. In respect of the elected members, it has given. In respect of the non-elected members, with reference to Article 80, Article 54 and Article 66 in page number 2 and 3, I have pointed out. Where it is required, it has been given for the elected members. Where it is not provided, it covers all the members. That is the interpretation which has been given for the purpose of voting right. So once that is the position, the judgment which would be applicable would be whether the supply of casus omissus would be permissible or not. Casus omissus cannot be supplied to such a situation. If the Constitution does not provide for the interpretation of the constitutional provisions, casus omissus cannot be supplied. Here the provisions are clear. In respect of Article 171, there is no exclusion of voting right to the nominated members. When it comes to 54, there is provided. When it comes to 66, it is not provided. So wherever it is required to be provided, it has been provided. Where it is not required, it has not been provided. So cash services cannot be supplied. That's the first proposition. The second proposition is from page number 6 onwards. The election will have to be conducted on the basis of the voters list as it existed as on the date of the election. Mere omission or erroneous inclusion or omission of the voters list will not vitiate the election. For that also the constitutional bench judgment in para 18 I referred, that is a law settled. Just because a wrong inclusion has been made, the election will not vitiate. These are the two legal propositions. I do not want to go beyond that. I am grateful for my notice here. I will also file this up.
Thank you.
Yes.
Only one line. Only.
That 1 line, 2 line you will give in writing to us now. 5 line, 10 line, 20 line, all free line.
Lordships are permitting all of us to file a note.
Yes, yes. All of you.
May just make one point.
No discrimination.
May just make one point in rebuttal, only one point. My lord, there are two varying philosophies. My lord, in relation to the municipal council meeting, my lord, the constitution provides nominated members will not have a vote because they did not want the democratic functioning to be effective. But my lord, in a legislative council, 1/6 of the members are nominated by the governor. They have a right to participate in the meetings of the legislative council. The legislative council's meetings philosophy is different. So, my lord, elections are to the legislature. Put it in the...
Thank you very much. Use the item 18 now immediately. So mention that. Thank you very much.
Your Lordships be taking up that review and not review, my lord, that item 41.
Let us see very quickly. Yes, item 41 is in my hit list. Item 18 very quickly. Only 40 minutes.
Don't push me out. We have the desirable thing of actually desiring to get into your Lordship's hearing. So that the...
8 minutes. CBI has filed it. See, when CBI has filed the 4th interim status report.
Sir,
Now,
my report is also here. My apologies, sir.
are you also filed, sir? Follow. And do you need some urgent directions?
Not urgent, but for the CBI, sir. CBI has given some suggestions. You can go over them. And then there are some matters relating to requests for de-tagging or deletions. If your lordship has some time, we could go over them, sir.
Now, CBI said, who is representing CBI?
The ASG was to appear, but broadly they are saying, sir, that
they are not seen in the field, they are not seen in court also. That's what is happening with us.
Broadly, in their report, they are saying that there are 45 additional petitions that they received.
I beg to appear, Malaz. We had handed over an envelope this morning, Malaz, of the status report. I'm sorry.
It's all right, Madam Ashurya. We got your the 4th interim status report.
Please, Malaz.
That you have received 45 more matters.
Yes, Malaz.
Out of these, you say 19 of these can be made part of the ongoing investigation.
Yes, Malaz.
Right?
Please, Malaz.
Now, what about the rest of the matters?
Malaz, 22 matters, Malaz, we are suggesting that the state, Malaz, economic offences wing can investigate.
That is where exactly we want to come straight on the point.
Yes,
why do you want state police to investigate?
Malaz, because this is, if your lordship see that table, Malaz, these are across the country, Malaz. Because the CBI is already investigating the financial institutions that are...
The matter which you have interested you
yes,
are also across the states. Some matters are of Gurgaon, some matters are of Noida, the others are Bangalore. These are the projects like. It's the question of location of the project. It's the question, first of all, the project proponent.
Yes, Malaz.
The developer.
Please, Malaz.
So if are the 19 or 20 matters which you want to send to the state police?
Yes, Malaz.
Do these matters pertain to some entire new set of developers?
Yes, Malaz. If your lordships will kindly have, I'll place, Malaz.
Well, assuming that is correct, Why should we discriminate among the home buyers? They will say, if in the case of XYZ home buyers, you are asking CBI to investigate. But in my case, you are wanting the state police. If the state police was so fair and if they were so prompt, by now, why these people would have suffered like this? So we had some hope from your agency.
Officers are also there in court, my lords.
Please take investigation in these cases also, like you have done earlier from Punjab, from Haryana and from Uttar Pradesh. You asked for and we provided you some extra police force of your choice. In these states also you can pick up the officers of your choice, we will provide that. Whatever logistic support is required, we will provide that also. But we can't have two parallel kind of five parallel types of investigations. One state exonerating, the other state partly holding guilty, and you are saying something else. That will create complete chaos.
My lords, I see what is falling from your lordships, my lords. Then your lordship may permit us to prepare a proposal and come back, my lords. The reason
and no question of preliminary inquiry. Now, after the initial hiccup, you have yourself found out that these matters require thorough probe. That's why you have gone for a registration of 28 RCs.
That's right, my lords.
So, no preliminary inquiry, go ahead, state, because we have to complete it also.
Yes, my lords. My lords, in the fresh matters, my lords, which involves new institutions, permit us to have a PE first, which can be converted into RC, my lords, if prima facie something is found.
The allegations are same.
My lords, they are not in all cases the same. In fact, I was going to make a very humble request to my lords. Maybe, yeah, my lords, after my lords have
first we get the FIR registered. You please now
that would almost be putting like a cart before the horse.
How have you completed investigation and filed charge sheets without subjecting a single bank official to custodial interrogation? If in these matters these officers are not caught, where are the necessity of even then investigation?
My lords, I don't have instructions on custodial interrogation, my lords. Lordships will permit me to take that also.
This will again lead to some then eyewash and then for years and years. By that time, many of us, where these poor homebuyers will go.
I miss.
Then what do you see?
I entirely agree with you. In fact, I was about to say that in all these petitions, but for two financial institutions, rest of the financial institutions are common.
Common? I see. That's it.
Financial institutions are common. The companies, builders are different.
Maybe different.
But since financial institutions are common, there are already FIRs filed against them. Maybe CBI can incorporate them also, sir. If I may add, from among the three cases that the CBI charge sheeted, in one of them was charge sheeted against Rudra Buildwell and its managing director and some other accused. Not against the builder or the banks was not involved. But in that case, I've received a couple of petitions from one Mr. Sundaram Iyer of Chennai, who has remonstrated that why the development authorities have not been taken to task. He's mentioned some specifics of how the development authority also colluded with the builder in extracting money from the home buyers. I've mentioned that in my report. My request to you, your lordship, would be that I could give that material to the CBI to further investigate upon the matter.
Absolutely.
Also, sir, in my report last year, I had made some recommendations about the general issues on which the CBI could inquire or investigate. They figure in para 39 of my report dated 25th of April 2025. I've reproduced them here in my report on page 53-54. CBI could also consider those general issues on which investigation could be conducted. While
you have identified the areas of investigation.
Yes, areas of investigation, not the specifics, but the areas. For instance, whether there is a separate agreement between a builder and a bank or not. For instance, some papers like this have.
This was the only issue which ought to have been very deeply investigated. That what is that nexus which are really successfully worked to the extreme advantage of the developers. They have siphoned money. Companies are now in liquidation, or companies are insolvent, and the projects are incomplete. The home buyers are running from pillar to post. The banks have the bank will of course say we are now entering into some kind of OTS. 20%, 15% we will take. Where the rest of the money has been, whose pocket it has gone? Where the country money has been siphoned. We have public money with the banks. That is something that's surprising us. Now, if we find that the way the investigation is going on, then on the next date we will constitute a monitoring committee of some criminal law experts and of some former judge. Then please don't say that some committee has been constituted to monitor the investigation. Then we will have to monitor it. We will not allow the CBI to disappoint millions of people like this. They are doing it.
Very small submission
The
at
CBI
this
has
stage.
filed.
My lords, would you allow us just?
No, nothing. You will go.
No, my lords,
you will go to
something different. I'm not going to be on any part of what my lords have said. Now, my lords, there is a report that's filed by the learned amicus.
We are right now only passing for the.
I am on something very slightly different. So we are different developers, etc., and different. We have different schemes, but whatever be that as it may, I'm not going to address my lords because my lords have appointed the learned amicus. My lords, I'm saying, may we have a copy of the report? We have our own statements. We will share that with the amicus. The amicus can place it before the court. We are not going to.
These are not claims or cross claims.
My lords, please, this is not the case. For example, let me give you an example. I appear for a party where there is not a subvention scheme, as my lords have heard from the others. It is linked to the stages of the construction, and the bank would pay only when the construction stage is linked.
If you are manipulated to coin or caption it in a different way, let CBI find out.
My lord, so therefore, now what is the consequence of my lord's order? The consequence of my lord's is that one part is CBI is investigating.
Consequence of our order was, if the CBI was fair, they should have taken you people in custody, find out where the money has gone, and something should have been paid to these people.
My lords,
You are waiting and waiting.
My lords, give me a moment, and that's only in furtherance with my lord's intentions in this matter, and nothing more than that. I would most respectfully submit that, apropos to my lords, the ED has stepped in also now. So we have a double whammy. Now we may have had 9 projects, we've completed 8. In one we may be struck, which we want to complete. We are stuck up now because of this. We can't even work it out.
45 copies of new SLPs have been received.
My lords, may we at least give our submissions to the learned AC?
Similar allegations. We have already told whatever you want to say, point out to the amicus. Largely
My lords, I
similar allegations.
Small submission. My lords, there's a matter which has been settled. It's regarding that between the home buyer and the builder. My lords, this is regarding
20 SLPs out of these are expected to be similar to those where matters have been entrusted to CBI for investigation. We see therefore no reason as to why CBI should not commence investigation in these 20 SLPs which pertain to the ongoing investigations. If need be, separate RCs shall be registered within 3 days, and investigation in these cases shall also commence. As per that. 19 case investigation are already going on, out of 20. So, we therefore endorse the CBI's viewpoint that these 20 matters can be incorporated as part of the ongoing investigation. Next paragraph. As regard to the remaining SLPs, the CBI has given, the CBI similarly wants to wriggle out of the responsibility entrusted by this court, suggesting that these matters may be directly to be investigated by the respective economic offences wings of the states. We disapprove such a stand taken by the CBI and direct them that instead of having preliminary inquiry, let regular cases be registered in respect of these remaining cases also, and investigation be commenced forthwith. Also, if CBI requires assistance of the local police of the states, especially economic offences wings, let a separate request to this effect be sent to the Director General of Police of the respective states, who in turn are directed to provide the requisite police power, police force on temporary deputation and at the disposal of CBI. The Director General of Police shall be obligated to provide the police force with the specified specialization, if any, within 1 week from the date of receipt of the requirement from CBI. No explanation in this regard shall be sent to the CBI. Even if there is any administrative impediment, such request shall be placed before this court, only after the requisite police force has been provided to the CBI, failing which the registry shall not entertain any request. Next paragraph. As of now, we do not want to comment on the quality, depth, and the investigative skills of the ongoing investigation by CBI. All that we wish to observe is that no one should be treated above law, and every suspect must be dealt with in such manner that the investigation reaches to a logical conclusion at the earliest. Mr. More the pendency, it will say the prolonging of investigation will lead to agony, will lead to more agony of the home buyers who have already been enough harassed by the builders and developers, apparently in collusion and connivance with the financial institutions, stroke banks. That's why the CBI is well advised to take into consideration every content of the report dated 29th April 25.
29th April.
29th April 2025, submitted by Sri Rajiv Jan, Lavendra Microscure, especially the areas of investigation identified and hinted in that report. Next paragraph. We direct a responsible officer of CBI to file an affidavit as to whether these aspects have been kept in view while filing charge sheets in some of the matters, and also a specific stand to this effect that these points these areas of investigation are being closely observed during the process of the ongoing investigation. During the process of ongoing investigation. Next paragraph. The CBI shall also, in its status report, disclose the estimated timeline within which the investigation shall be completed in respect of all these projects. This court cannot wait for an indefinite period for conclusion of the investigation, from especially keeping in view the several instances in the past where investigation itself has taken years, so one can well visualize the outcome of the trial, the timeline within which then trial will be over. Next question. The home buyers, the financial institutions or any builder developer shall be at liberty to submit their claims, cross claims, suggestions, recommendations to the learned amicus bureau for his consideration. No such claim shall be directly entertained by this court unless it is screened through the learned amicus.
My lords, one
Lordship, may I clarify?
status report at least be provided so that we know what we have to deal with. My lords, and my lords, learned amicus curiae report.
Lordship,
Those two may be provided.
clarify that 17A of the Prevention of Corruption Act will not apply. Your Lordship has done it in other
Counsel
cases.
for the parties may request the learned amicus to share the relevant extracts of the status report.
My lord.
Status report.
My lords, we can pay for that. It
So
will be provided.
My lords.
We however do not express any opinion in that regard. Learned amicus curiae will take a call as to whether sharing of such information at this stage will cause any impediment or adverse impact on the ongoing investigation.
The Lordship, may I clarify?
Just to say that if sharing of such information is likely to cause any adverse impact or any prejudicial effect on the ongoing investigation, there is no obligation to share that information.
Correct. The Lordship, may I clarify about 17A.
Deal with anything in that.
In terms of Lordship's order. 17A of the PC Act should not apply. Your Lordship has directed in the other cases because it's a court-directed investigation. Because all these bank officers are involved. Your Lordship might direct that 17A of PC Act that permission may not be necessary for the CBI to take.
We have already passed the order.
That is in the other matter.
On the last.
My lords, please allow me to make a small submission. My lords.
No, my lords, we have understood, my lord. We'll comply with.
That's one request I have.
Very well.
Plus one request I had on the last occasion against one party. Your Lordships had issued bailable warrants. 24th February 2026, Lords, one of the SLPs against the builder, your Lordships had issued a bailable warrant because so far as that petition was concerned, they wanted a flag.
What happened?
Party is here, Lords. What has happened? He also approached the railroad.
That's bailable.
Lords?
You are representing that bill.
Yes, Lords, I am representing.
Why bailable were issued?
Because we were not represented in the court, Lords, and we had not reserved one flag for that petitioner who had come to your Lordships. That was not a subvention scheme matter. What has now happened, the petitioner had gone before the RERA, she wanted a complete refund, that refund has been given. We have satisfied the decree of the RERA, my Lords.
File an affidavit.
No, we have done that. We have filed a short affidavit.
May I mention, my lords,
Plus, your Lordships have issued a bailable warrant, my Lords, I am here.
Why not bailable what is above the law?
No, I am not saying that. Would your Lordships, I have filed an affidavit to that effect.
Therefore, that is appearing, otherwise today we should not bailable.
I understand, my Lords. I understand. Would your Lordships only say, my Lords, now that he is represented here, my Lords, let the amicus look into the affidavit. We have said we have satisfied the RERA. They can't have.
Don't submit your claim to the.
There's one. Item 43.1, my lord.
The Lordship, few items. It's available.
Item 18.49, 18.50 and 18.103 is prayer is to withdraw. Those are permitted to be withdrawn.
Please, my lord.
All right, thank you very much. Now item number 23.
My lords, please allow me to make one small submission, my lords. My lords, my lords, one small submission.
Thank you very much. Go and show your claim, whatever.
I've done what I could.
My lords,
Lordship, may kindly appreciate, I have a small request.
my lords, may allow me to make one small submission, please.
I'm 43.
43 उसके साथ कर दो ना उसको.
Lordship,
My lords,
Lordship, may kindly appreciate.
Item 43, my lord.
62, we have arrived at a settlement with the home buyer, but unfortunately, the builder has not been added as a party before this honorable court. I came to know about proceedings only once the CBI sent me a notice.
Go to talk to your home buyers and.
My lords, they agreed, there's a memorandum of understanding, they agreed that they will withdraw.
So that memorandum, I said we will not entertain anything directly.
My lords, I have moved an application for implementation as well as for direction. My lords, may.
First, go and satisfy the.
My lords, do you permission, may I mention, my lords, that
Thank you very much, thank you.
there is an intervention My lords, I have to request.
Better use two bikes. Better use two bikes then. Their voice.
My lords, may I mention in 18.9, there are two applications filed by the home buyer. There is an intervention application, it was on defect, so it could not be allowed on the last date of hearing.
Just to mention these applications. We are not entertaining any individual claim. Whosoever want to.
My lords, this is a home buyer, my lords, in idea.
Home buyer, go and tell the learned Micahs.
We have already submitted the detail, my lords. There is a 130 petition.
May I make a small request? May I make
My
a
lords,
small?
there is a 130 matter going on in.
Just 30 seconds.
We will dismiss if this unnecessarily this home buyer you trouble.
The last
We
occasion,
have already created a platform for them.
on the last occasion, there was a direction to the London amicus in para 19. Certain transfer petitions were filed. The amicus was asked to look into it because the high courts were.
There is no need of transfer of these applications.
May I make a small?
No, don't recommend, and all transfer petition may be dismissed for the term.
My lord, may I make a small?
People are burdening us.
My lord, may I make a small request?
Eligible situation.
Lordship, may I make a small?
18.20, it is a fresh read petition, my lord. In this,
May I make a small?
In the press matter, no notice will be issued, simply tag them. No notice to be issued.
My lord, in item
By mistake one.
My lord, bank has initiated the recovery proceeding in 138 matters.
My lord, 4th of February, Lordship, on.
It's all right now.
My lord, in a fresh matter, I may be permitted to file a
My
claim.
23.
My lords, I
May I
have.
make a small request? Lordships, on 4th of February at paragraph 20 of the order, Lordships have in 4th of February order at paragraph 20, Lordship has issued bailable warrant against the builder. Now, my lord, still date, he has not complied with the two orders passed by this honorable court.
It's all right.
Lordships taking permission to withdraw the application 18.50, my lord.
We have already permitted withdrawal.
1.16 also.
My lord, kindly seeking the proceeding, my lord.
See, item 23. So we will not, that's the only way to deal with now.
Bank has initiated the,
Getting unmanageable affairs.
my lord, bank has initiated the recovery proceeding and lordships in our matters.
No stay, no notice. That's the only way.
I may be permitted to file a fresh claim by end of the day, lordship. I do 43 is a fresh matter.
Notice. Registry को order कर दो, no entertainment.
It'll be called out. Lordship, you could
Now item
consider,
23.
it's a fresh matter.
My lords, I'm sorry, I have one request, my lords, from CBI, my lords. Lordship have said within 3 days RC to be registered, my lords. Would your lordships give us a slightly longer time or 3 days from the order is uploaded, my lords?
1 week or we can have 24 more hours.
Lordship, item 43.1 is a fresh matter, my lords.
1 week, my lords.
Lordship, item 43.1
One
is a.
issue I wanted to flag, my lords, which
No preliminary issue now. No preliminary.
I bow down, but these, my lords,
Finish of inquiry must be stopped.
my lords, your lordships have let us do that item 8. All that I want to point out, one more thing is there are some people who want to now enter into compromises for pending investigation.
If the settlements are bona fide, the learned Micahs will make a report, we will consider. Will depend upon that part.
Lordship, 18.8.
Transfer petition and other matters in my report, we could take it up on a subsequent.
We will take up on.
Your lordship, item 18.85 and 86, I am the respondent number 6, I had sought deletion, I had moved applications, they were allowed, but my IAs are still showing pending.
Thank you very much, thank you.
Your lordship, my deletion was allowed, I'll give
Item
it
23,
bird.
please.
Most obliged.
Lordship, my claim may be permitted to amicus curiae by end of the day, I'll file.
If you want us to get up, go in the chamber, we will do that. You will not permit us to take next matter.
Lordship, 43 is a fresh matter, my lords.
We will take whatever it is, fresh or no. 23, right now, 23.
43.
My lords, 23, they were supposed to comply.
May I?
Dr. Singh is there, my lord.
I'm here, Malis. I'm here. Our lordship will note for us against 925 crores, only 125 crores have come.
Order. May I make a? Come.
Well, just give me one.
The shares the substitute of shares and alternate removal of cash deposit or something was supposed to be done.
Give me, it's okay.
Yes, sir.
Good evening, sir. 5th of February 2026. May I just take your lordships to the order? Yes. And indicate, my lord, the total compliance with the directions. My lord, in relation to PC, my lord, in para 1, in reference to the previous order dated 12th of February 2026, respondent number 1 has filed an affidavit which is taken on record. In a purported attempt to honor the observations which this court proposed to issue on the previous date, refurnishing a security comprising of INR 600 crores with the registry of this court, the deponent respondent number 5 has offered the following 3 assets. Well, on item A, your lordships have noticed, well, your lordships recorded that your lordships were not satisfied. Your lordships gave me time, my request, and I will address that because I have got some instructions. Now, please come to para 3, Milo.
Yes.
As regard to 37 acres of property known as Metro land, let the original title deeds thereof be deposited with the registrar judicial of this court with an affidavit of undertaking that the subject land is free from all encumbrances except that it was earlier attached by the Directorate of Enforcement and was released subject to furnishing of an indemnity bond, and that this land was further subject to an ad interim injunction that has been granted by the Civil Court on 19th October 2023. In this vein, respondent number 5 shall be obligated to furnish an affidavit along with an undertaking to the effect that the requisite indemnity bond has been furnished, thereby complying with the release order passed by the Appellate Tribunal under the Prevention of Money Laundering Act. Well, in terms of this order, Mrs. Reddy, that is the daughter, has filed an affidavit. She has also tendered, my lord, the title deeds. They have been deposited with the registrar. My lord, there are 9 envelopes which contain the originals. They have been, my lord, deposited. And my lord, we have also served a copy of the same on the other side. My lord, then may I come to para 4, my lord? Yes. Insofar as the third part of the security, namely the additional cash security of the INR 125 crores is concerned, so and so on instruction states that a sum shall be entrusted to the registrar judicial of this court within 1 week from today. Now, the indemnity which had to be offered by my client has also been filed. He has undertaken that in case, my lord, there is a claim of that 1 crore 25 lakhs in those proceedings, he will make it good. So that, my lord, there is no encumbrance as far as these 37 acres is concerned. The 125 crores, my lord, has also been deposited. And, my lord, suitable, we have, my lord, the deposit slip issued by the registrar. My lord, we also have an office report which clearly indicates, my lord, what I have stated, my lord, has been complied with. There is an office.
We are only left with
we are left with 1. Now, my lord, in relation to 1, your lordship's observation, my lord, I communicated it to my client. I advised my client, my lord, may I tender an additional affidavit on behalf of my client. Because, my lord,
why don't you do one thing, Mr. Subhash? You give a copy of the.
Yes, I will. I will.
To Dr. Singh or Mr. Gopal.
Yes, sir.
And if it is agreeable or.
I'm doing something, my lord. May I straight away say this? Where are those envelopes, please?
Certainly look into
it. My client, my lord, is depositing 100 crores. My lord, he has got 2 bank drafts. Just 1 moment, please. My lord, may I just place the affidavit because I want to go strictly by, my lord, what has been described in the affidavit. Please take the affidavit, my lord. That is the additional amount. My lord, additional security in order to obviate, my lord, any concerns with reference to 212 crores. My client, my lord, has put together, my lord, in two bank drafts, one of 75 and another 25 crores, my lord, 100 crores. I, my lord, if your lordships will so order, I will deposit it with the registrar immediately. I have, my lord, these drafts. And, my lord, the properties which have been attached, so, my lord, the total available security now is 633 crores. Your lordships will see that on page 4 of this affidavit. And this also, my lord, is an additional affidavit which has been filed with the undertaking. And your lordships will notice in the attached assets, before my friend begins, may I just please see page 5, my lord. In addition to these 100 crores, which is, my lord, a cash security which I am depositing, my lord, there are two immovable properties at para 7A and B, which stand attached. But, my lord, due to the prevailing circumstances, we were not able to get a proper valuation done in respect of this. We'll undertake a valuation and place that also.
So the only thing is that these will be attached
by the trial court, the executing court. Now, well, I must tell your lordships, in fairness, two more points, my lord. One is, my lord, in fairness, it's correct for me, my lord, to disclose that my client had filed two interlocutory applications challenging the maintainability of the execution petition on the ground that, my lord, they do not conform to the provisions of sections 44A and section 13. My lord, they have come to be dismissed recently. 2 days ago, my lord, an order has been orally pronounced because there are two different commercial courts. They have dismissed, my lord, those applications. My lord, because it is a commercial court matter, there is a statutory remedy of an appeal. But, my lord, I have advised my client, subject to your lordship's leave and your lordship's graciousness, we will file an appeal, my lord, against that straight away here, so that your lordships have an opportunity to examine whether it is well grounded. If it is well grounded, my lord, then I submit with respect, then, my lord, there is no doubt, then the execution petition will have to go. But that's one point. The second point, my lord, without prejudice, my client is also in conversation with Dr. Singhvi's client for the purpose of finding a resolution. I must tell your lordships because as an officer of the court, I must make both these disclosures.
Now, can I take 30 seconds?
With this 100 crore more we will take, we will direct the registry to keep them. The registry will accept that. Now, let us for the time we ignore these two properties which are attached by the trial court. So we will have a broad security with us of the 37 acres land and 225 crores in the kind of cash of the FDRs with us. Now, just a minute.
I'm sorry.
Saying something else which both sides are not saying.
Yes.
Now, with the security in our hand, is there any chance of going for the parties for mediation?
May I just say, can I just take 30 seconds? Number one, I will look into the affidavit and take instructions. We are not against.
Mediation may be little discomfortable for the senior counsel.
No, just give me 30 seconds. Give me 1 minute. Give me 1 minute. We will take instructions on the these new affidavit and new securities. Number two, I will also seek instructions on the mediation. Number three, the total security is effectively 225 crores, including the 100 today. The Mitchell land, he claims to be 408 crores, is encumbered according to us. And as your lordship observed last time, if he's so sure of his security, he can sell the land and give us 408 crores. Let him sell the land and give us 408 crores. That's the reality. Now comes the additional securities offered. We will of course take instruction. I'm not saying anything today. But please note, against the 925 odd crores, effective securities 225, disputed securities 408. That disputed he can perfect by selling the land and giving the money in here.
Yes. That we will see later on. First that is only an argument on merits that we will consider. When question of compliance of an order we have already passed. As of now, we are only saying that partially or substantially. partially or substantially, where we have secured the interest of the petitioner. Again, we are using the word partially or substantially.
Absolutely.
Will it be an option the parties would like to exercise to go for mediation? That's all. We are stopping today's proceeding only on this issue. You can have instructions.
This we can take instructions on, Madam. We can take instructions.
The mediator will be essentially only from India. The mediator will not be from outside, but mediator will be a person of course, some eminent personality who will be above board, and there should not be any difficulty for both sides to.
Manoj, I welcome the observation.
May I just add something? Mediation finally, that's great. If it can bring an end to this entire issue of decree. But in view of the fact that today you have substantial or full security, the attachments and injunctions against other parties, that should be lifted today, Why should that after that? One minute, please. This is on 100% security. Normal rules can even be 50%. As the Chief Justice has remarked. With this 600.
We are asking only for next Monday, Mr. Odgi.
Should we keep it Monday, Otherwise,
next week,
there is no reason why the attachment should today continue
May I just say one thing, Lord, if you Lordship permit me one thing.
So
1 minute.
We will not modify any.
No, only one sentence, my Lord, if you Lordship permit me. My Lord, there are companies whose day-to-day working and servicing of debts are affected because of the order that you will about personal assets. Now, if I can't service the debts of my bank, if I can't pay the day-to-day wages and expenses, my Lord, the company will go into liquidation. That was not the idea of your Lordship, my Lord. It's my respectful submission.
We will not modify any of that.
Allow me the day-to-day expenses. I will file the accounts here. File the accounts why I am spending, my Lord. Because, my Lord, after all, the companies have to function, the laborer has to be paid, the bank has to be, my Lord, debt servicing has to be done.
Mr. Kumar, we don't want to go into the factual aspect.
No, my Lord, these are daily routine matters for a company.
Not that we pass this kind of unusual and harsh order unless the circumstances are so warranting it. So it's
I have never been a party to the entire proceedings, my Lord. No execution is sought against me. And my Lord, before this honorable court, in my absence, my Lord, an order is Lord, passed by your Lordship, my Lord, with all due respect and humility, I say, my
you
Lord.
can confirm that order after hearing. There is no difficulty.
No, I am only making a humble request for the company should not go under it. Why should the laborer suffer, my Lord, the worker in the company?
We will not fault in Monday.
The worker in the company.
Your Lordship, keep it on Monday.
Monday, Valentine.
Keep it on Monday, my Lord. Then it may be worked out on Monday.
That's right. 25th February 2026. An additional affidavit has been filed on behalf of, by former respondent number 5. By respondent number 5, respondent number 5, primarily to address para number 3 of the order dated 25th February, para 2 of the above stated order. The Gopal Subramaniam, Land Senior Counsel, representing that exponent, has at the outset referred to para 4 of the affidavit filed today, whereunder an additional cash security of 100 crores of INR 100 crores has been offered by way of two demand drafts of INR 75 crore and INR 25 crore. These demand drafts have been brought in the favor of the registrar of this court. Let both the demand drafts be handed over to the registrar judicial of this court during the course of day. Next paragraph. The reference has also been made to para 7 of the affidavit, wherein it is pointed out that two immovable properties referred to as serial number A and B have also been attached by the civil court.
Executing court.
Matched by the
executing court.
The decree is
By the executing court. So the value of those properties could not be ascertained. Next paragraph. In light of the fact that the respondents have as of now furnished partial or to the extent of partial or substantially claim the respondent has furnished adequate security to the extent of partial or substantial claim of the petitioner, we have persuaded Lansing Council for the parties to explore the possibility of a settlement through mediation. While Sri Gopal Subramaniam, mentioned, Mr. Diwan, all are agreeable from the respondent side. Dr. Abhishek Manu Singh and Mr. Gopal Sukarnanan Lansing Council presenting the petitioner side seeks and seeks some time to have instructions. Without prejudice to the submissions to be made by the parties, post the matter on Monday for the purpose of exploring the mediation. It is clarified that the mediator in bracket S, there may be more than one mediator depending upon the situation. Shall be from India, shall be only from India. But some mediator, some eminent person shall be from India. Post this matter from Monday. We will take up the rest of the issue on Monday.
Certainly.
Yes.
Lordship, please.
Well, just one sentence, that 100 crores which is being deposited, that also that one line can come in that it's being put in an interest bearing account, etc. You put it for the other one.
It can be placed.
That can also.
That's it.
Now we take up item 41, judicial offices matter.
Yes.
In the meantime. Lord, there's only one request, my Lord, which I wish to urge for your Lordship's consideration. My Lord, we are all trying to explore the best possible way amicably to resolve this matter. My Lord, my client, I think quite a few of our clients have been receiving, my Lord, a lot of communications attacking the family members. My Lord, they are not connected with this decree. It is only my client who is, my Lord, involved. He is the person judgment debtor. But, my Lord, to attack all members of the family by communications is not appropriate. I'm only appealing, my Lord, to my learned friends to advise their clients to refrain, my Lord, from pursuing members of the family. After all, my Lord, it's a large family, there are children, there are grandchildren, my Lord, they all can't receive communications. My Lord, if I were to tell your Lordships, I am in fact quite horrified to see that, my Lord, repeatedly all the proceedings and orders which your Lordships pass are elaborated by way of additions and suggestions.
I don't think Mrs. Subramanian needs to labor further.
I really think.
No, I take it on advice. If this is true, we will ensure this is rectified. We will ensure this is rectified. This doesn't need to.
We are creating a different kind of environment now.
Absolutely. I take it in good spirit. We will ensure that this doesn't.
No precipitating action.
But I would just request my friend, if his solicitors can just share those communications, we'll definitely take a look.
Thank you.
I'm great. Micus had a note, I think, for your Lordships in this, the judges matter. It's mere implementation of the.
Question my direction that resolution matter.
But may I hand over just a 2-page list of dates, which will show as to how this matter has progressed. May I just hand over, my Lord?
No, list of dates for what?
For showing that these people, my Lord, were permitted to take the exam by virtue of interim orders, because most of the High Court rules did not permit, my Lord, the judicial officers to sit for that exam. So they filed writ petitions, they were permitted to take the exam. After that, they got selected. Then, my lord, interim orders were passed by this court saying that now you appoint them. Some got appointed, some were not appointed. Thereafter, my lord, when it went to a different bench, that bench said, all right, now no further appointments of these in-service people. Advocates may be appointed even though they are lower in the merit list, but that will be subject to the final judgment of this court. Now, the final judge, then, my lord, the matters got referred to, as was held later on, to 5 judges, saying that this involves an interpretation of Article 233. Unfortunately, the matter was placed before 3. The 3 decided against us. Reviews were filed by several people, though in those reviews it was held that no, this should have gone to 5. It ought to have been decided by 5 because there was a reference order citing Lord 145 of the Constitution, which says that where there is an interpretation, a substantial question of law involving interpretation of an article of the Constitution, it must go to 5, and that order was already there. So therefore, since it ought to have been decided by 5, we now refer it to 5. Now the 5 have decided in our favor, and the question is, my lord, all these people who were permitted to take the exam, who have qualified ahead of the lawyers as to whether they should be given the benefit of that or not. So therefore, not just a
That's what we have already argued, we understood what we argued.
Just one more thing, Lord.
Yes.
No, the records are already out of control.
Many of the.
We have argued and we have understood what we want.
Just one more thing, Lord.
These are 4, yes.
Just one more thing.
Suggestion is that Lordship takes it High Court wise, your Lordship.
Just one more thing. Now, Lord, insofar as those whose reviews were pending, that according to me is absolutely clear that the reviews were pending. Ultimately, it will be based on, my lord, whatever happens in the review petition, and therefore ultimately the 5 judges' judgment is in our favor. So they have to be given the relief. There is a large amount of case law which says that if you ultimately succeed, but you were not appointed in time, you will be given the benefit of appointment as of that date with seniority. So we have given, my lord, the case law also with my note. And just one more thing, for those, there are several people who filed reviews, but those reviews, my lord, went to that same bench and that those got dismissed. Some reviews were kept, my lord, pending, ultimately resulted in the Constitution bench judgment. So, my lord, it should not make any difference as to whether your review was dismissed originally. Ultimately, the 5-judge bench judgment should prevail. That's one thing. The other thing that, Lord, we have given one judgment of this court which says that in case of lack of subject matter jurisdiction, the judgment is a nullity. So, Lord, once your lordships have held that the matter should have gone before 5, then the 3 judges who have decided, my lord, lacked subject matter jurisdiction because according to 145, and there was already, my lord, and
one way that the moment these officers will now start opening their mouth too much here and there, then we will put these matters in the regular track and it will take years. By the time, hopefully, they will retire.
Can I just read one sentence? Just one sentence. It's the Constitution bench, para 170. It's the concluding part. In any case, we clarify what we have held in this judgment will be applicable only from the date of this judgment, and in no case any selection process completed or any appointment made prior to this judgment would be affected, except, and this is what all of us are relying on, except in cases wherein any interim orders were passed by the High Courts or this court. In such case, the issue would now be governed by the orders to be passed by the bench hearing the matters. Every single one of us were covered by interim orders of this court. Allow me to complete. After a slew of interim orders were passed in a series of review petitions and applications, your lordships finally passed an omnibus order on 12th July 2021 saying that no more applications need to be filed. We are permitting the interim relief to be granted across the board even if you don't approach us. We are all people who had filed review petitions. I am appearing in fact for one individual. It will be in the chart. One individual who in fact was appointed. He was appointed and then the Dheeraj More judgment of your lordships had come on 19th February 2020. That's a 3-judge decision. Next day, in great rush, they reverted him back to a civil judge. He's meanwhile now become a district judge. So for many of us, I'm speaking for myself and a few others, for many of us, it's a question of seniority. Because he has seniority from 2017 after having fought this consistently for 7 years and having succeeded and having had an interim order in his favor. Surely it's only a question of adjusting that
Also succeeded by virtue of the 5 judge bench only.
Yes,
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 Lord.
yes, yes, yes.
Your lordship, if your lordship
We were,
takes High Court wise.
we were given appointments based on interim orders of this court.
Yes.
That is,
The
If
law
your
was
lordship
already
takes
set
it up High Court
now
wise,
because-
we can show to your lordships that there are, at least like in Allahabad, your lordships, there are only 52 persons which are before your lordships and vacancies are 400.
Where is your-
And the replies have also come from the High Court, your lordships. So if your lordships just takes it up High Court wise, your lordships, the exercise will be much easier.
I think the amicus has a note where,
I agree, Lord, it should be taken in.
Yes, my lord,
court
you can
case.
go-
no, let's not
Because-
overcomplicate this. Amicus has made it 4 categories. Those 4 categories, because otherwise high courts, it will take 20 high courts, 25 high courts.
Yes.
Those 4 categories should be enough.
According to the amicus's note, lordships may deal it High Court wise because your lordships, the rules are there.
May I
And the
suggest something?
seniority can be decided on the basis of the rules.
No, like for example.
Judge, we made a table of all the cases in this batch, 1 page, just 1 page. It shows what we believe is the correct position. If your lordships will just see this.
Like for example, in Kerala, my lord, there is no interim order. There are only 4 people, my lord, and they have been, just now got this judgment. There were no interim order also. Now to unsettle the seniority which has been settled will become a very serious problem, my lord.
Your lordships, we have been agitating this for the last 7 to 10 years, your lordships. 2014 was our selection. We went to High Court, we've done several rounds and we have succeeded finally before your lordships.
no, our difficulty is that it's very nearly impossible to issue any general direction with regard to.
That is the reason why I'm saying your lordships will take it High Court wise.
Now there is no confusion about law. Law is very clear.
Absolutely,
It has
lordships.
that the judicial officers who are
Yes.
entitled to compete.
Yes.
They were wrongly denied that opportunity.
Please, your
But
lordship.
unfortunately, even that denial was
Unjust as far as we are concerned.
one high court completely indulged in doing injustice to them. Some of courts dealt with partially,
they appointed them.
granting opportunity.
Please.
The other did in different manner. So the facts are varying from high court to high
We've
court.
classified it, my lord.
So general principle will be now, first, who are the persons, the 11th amicus are the persons who have been appointed?
No, so
But their appointments have been evaluated.
this chart illustrates that. There are 3 classes of people.
There's one more aspect.
If it can be seen.
All right, first is.
Your lordships, the amicus is, I think, it
There are-
received with
there are
5 High Court's responses,
4
that 1 page your lordships had said.
There are 4.
No, there's one more aspect that practically everybody is now in HJS.
There are 4 cases in which appointed and retained, they are in service today. 4 of them.
Item at page
Just a
16.
minute, just a
Punjab
minute.
High Court. Punjab and Haryana.
Say,
At
the
page
controversy
16.
before us
No, 1 second.
revolves around giving effect to the directions that have been issued by.
Why will it take forever? 5 minutes for High Court?
In Rajnish KV versus K. Deepa and others, civil appeal number 3947/2020, decided on 9th October 2025. So the Constitutional Bench overruled the earlier 3 judgment decision of this court in There is More versus High Court of Delhi, 2027 SEC 401, and has issued directions contained in para 172 of the judgment. So, however, for giving effect to those directions, the findings stroke observations made by the Constitutional Bench in the entire body of judgment also have a material bearing. So, therefore, the directions alone cannot be read in isolation. It is the entire judgment that has to be given effect in its true letter and spirit. Next paragraph. The learned amicus curiae was requested to assist us for recommending the manner in which the directions by the council bench can be given effect. एक चीज इसमें ऊपर ऐड कर देना नया पैराग्राफ. Just to recapitulate, comma, it will mention that the council bench judgment pertains to eligibility of the judicial officers for the purpose of competing for direct recruitment in higher judicial services. So, some judicial officers were having some of the judicial officers, some of the judicial officers might be having a part of the say practice at bar to their credit before joining the judicial services. The others may not have even practiced at all, and practiced at all, and they sought and they asserted their eligibility by seeking they asserted their eligibility on the premise that the judicial service rendered by them should not be treated inferior to the practice at bar. Also, all these debatable issues stand now resolved by the Constitution Bench. उसके बाद ये कराएगा in order to give effect to the next paragraph. Now, last new paragraph. The learned Micus QA has submitted a self-explanatory note dated 16th December 2025, broadly suggesting 5 categories of judicial officers who are entitled to or may not be entitled to the benefit of the subject judgment. As per next paragraph. So while dealing with the first category, namely the persons who have been appointed, but subsequently their appointments were cancelled and they were reverted on account of applicability of the erroneous principles of law that have since been overruled by the Constitutional Bench, there cannot be any doubt that such reversions are liable to be declared illegal, be ordered accordingly. All these judicial officers who had earlier been appointed shall be deemed to be continuing in service along with seniority, benefit of seniority, and notional pay fixation benefits without any areas of pay. Next paragraph. The second category of judicial officers are those who participated in the selection process which was complete in all respect, but final appointment orders could not be issued as there arose clouds on their eligibility.
No, there was an interim order of the court.
Eligibility on account of judicial intervention.
Yes, sir.
On account of judicial intervention.
There was no interim order.
This is Arun Mishra's order, was it?
Judicial
They could not secure any interim order.
We direct the high courts and the state governments to offer appointment to all the judicial officers forthwith, which shall be initially with effect from 10th October 2025, that is a day after the Constitution Bench judgment was delivered on 9th October 25.
Yes.
However, since the issue of determination of intrinsic seniority are complex issues based upon facts which are varying from High Court to High Court, we direct that their seniority vis-a-vis those officers who have been appointed during meanwhile, namely after their selection process was complete, but before before their appointment to be made now under the direction of this court, the intrinsic seniority shall be determined by the High Court after hearing all the affected officers, or all the officers who are likely to be affected.
Absolutely.
So for this purpose, the High Courts are directed to constitute a committee of at least 3 senior judges of the High Court.
There is already a seniority.
Your Lordships may just indicate.
There is a seniority committee already.
Promoted. We've already been promoted, your lordships, now during this interregnum.
Shall be heard by the committees as per their existing practice, as per their existing rules or practice.
Yes, your lordships, as per the roster.
However, the seniority shall be placed before the full court of the High Court for, for final determination.
Your lordships may make it time bound.
The aggrieved officers shall be at liberty to approach the court of law, on the premise that a first cause of action has arisen in their favor. The first cause of action has arisen therefore, their favor, full stop.
Lordships may prescribe a time for the committee.
The High Courts are directed to determine the interest seniority of these officers within a period of 3 months.
Very great.
Great. Lord's High Court has issued recommended letter, so it said yes for recommended letter, my lord.
No, Lord, there is another category.
So like now,
There is
now we agree to.
District judges.
Adverting to the third category of officers, namely the persons whose selection process has yet not been completed, we direct the High Court to treat such officers eligible and complete the selection process in accordance with the service rules, in accordance with the governing statutory service rules. In the event the judicial officers who had applied and who were expected to participate, who had applied and were expected to participate in the selection process, it makes in the final merit list, they shall be offered appointment by treating them fully eligible in view of the constitutional bench judgment. However, such officers shall be entitled to seniority prospectively.
Absolutely.
Prospectively.
Yes, sir.
And in such cases, the old settled seniority will not be reopened. Next paragraph. E. In respect of the officers who are yet to participate in the selection process, we are of the considered opinion that no imaginative right can be created in their favor only because at one point of time they were eligible to participate in the selection process. However, if such officers have become overage, the age relaxation shall be granted and the High Courts are directed to initiate a fresh selection process, giving them opportunity to participate. It needless to say that if these officers also qualify and are selected, they shall be entitled to appointments with the age relaxation.
Lord, if there is vacancy.
Category C, my lord.
Lord, if there is vacancy.
Category, may I just request your also may I just invite your, I'm sorry for indulgence.
Subject to existing vacancy as per.
I'm sorry for indulgence. The latest category that your lordships have said.
Subject to existing,
Lordships also, it will be done edited.
There is a yearly recruitment, so vacancy.
As per Malik Mazar.
Correct.
As per Malik Mazar. Correct. So that is one thing, and may I just make one request, my lord? I'm sorry for intervening.
Just a minute. First we complete the order and then we will hear. Post this hearing we will hear.
No, your lordship.
You are the only silent advocate.
There's one category left out.
Yeah, my question.
In the order.
Last category of the persons, bar associations who are challenging the appointments of the judicial officers. So all such challenges are liable to fall flat in view of the constitutional bench judgment of this court. All these petitions pending in this court or pending before the High Courts are deemed to have been dismissed.
No, my lord.
Are deemed to have been dismissed.
They must be one edit dealt with accordingly. My lords, may I mention there is another category which.
Your lordships may.
Lords, in D category, my lords, may I just reiterate my request?
Judge, my lord, I take the direct recruitment exam. I have interim relief from your lordships.
The problem is no problem. Look at next paragraph. In all fairness, there are several other related issues that have been raised by London Senior Counsel, Stoke Counsel for the party. In the absence of specific pleadings with reference to each High Court, we are afraid we cannot go into those questions. The same are kept open, firstly to be raised before the committees of the High Court as directed in para so and so of this order. Also, in any case, those contentions shall remain available to the parties for, if need be, to be raised in appropriate judicial.
This order
This is the fastest.
not allow me a submission only, my lords. My lord, allow me only one submission.
42 and 40.
Your lordship, just one more clarification. My lords, allow me one submission only. There are petitions pending in. No, my lord. Not covered by that, not, these are, like in my case, 41.6, we are selected.
It's important.
There were revision, just allow me,
Correction for your appointment.
that's not covered here, my lords, in this five categories.
Where the person have been, जहाँ पे लिखा ना उसमें category 2 or 3 में.
This is
उसमें line है.
Madhya Pradesh High Court, we are the advocates quota people, my lords.
Where the candidates had participated and had also been selected, but the High Courts kept the High Courts withheld the appointments to await the decision of this court. It goes without saying that such officers shall also be entitled to appointment with effect from 10th October 2025, the same date, were subject to a determination of their interest in senior.
Just one clarification, my lord. Just one clarification. This is the fast.
There is one problem, my lord. There are a large number of people who took the selection process in 2014 under interim orders of this court. By the time the selection process got over, then comes that order of Justice Mishra saying no appointments to be made. Since they were in service, in the meantime in 17, 18, 19, they have been appointed by promotion as additional district judges and now even as district judges.
That will be a separate category.
So we are covered in category 2, but we want that we should only be considered for notional seniority. Yes, yes.
That is in category 2, my lord.
That has also.
There also, my lord, that issue will have to be seen by the High Court.
That the judicial officials at one point of time applied to compete for direct recruitment, but were not permitted and or the selection process was not completed or despite selection their appointments were withheld on account of the uncertain on account of uncertainty created by the different judgments of this court
or interim order.
On account of the
interim order
of this court or uncertainty on the legal position, and if such officers have meanwhile been promoted as per their seniority in the
civil judge senior division
cadre, the subsequent promotion shall not cause prejudice to their claim for direct appointment.
Great.
And or to claim the seniority. However,
We decided by the High Court.
That seniority, there is no discussion.
How else will
whether
it be?
they are entitled to seniority or not, and if so, from which date they will be entitled to, shall be determined by the committee, by the High Courts. In this regard, we have not expressed any final opinion on merit.
Just can there be a timeline for the first category?
Aspects of selection.
Can there be a timeline for the first category?
May I just point out?
My lords, allow me one last line to be added, lords. In Madhya Pradesh, my lords, in Madhya Pradesh 2017. Lords, in Madhya Pradesh in 2017 examination. Just allow me one line. Lords, allow me.
There is nothing like Pradesh, why we have issued pan-India direction.
One Pradesh only now. They will all go by the service.
All right, item number now 42 and 47. MC Mehta matter, where is the learned amicus?
Your Lordship will just have 41.
Unable to come inside.
Mr. Guru Krishna Kumar, we will pass an order. We have done our homework. We are going to segregate these cases. Yes. In different categories.
Yes.
We will, you also give, if you have done your homework.
Yes, we have done our homework.
So you hand over to us. And we will prepare a draft order which both of you will then see and then we will pass it.
Very well. I had one request in that.
84, 85 will eliminate.
Yes.
And new series of.
Correct. In fact, my lords, one certain categories, we are suggesting to send back to the High Court, my lords, to send to the High Court.
Maybe.
I had one other practical problem, my lords. I need a minute of the court's time. Earlier, my lords, in 2022 and later in 24, list of about 100, 150 IAs were given, my lords. Some of them were sent to my lords Judicial Committee. But now about 40 IAs initially were given last week. But now, day before yesterday, some 350 IAs have been given, my lords. We don't have copies of many of them. I don't even know.
Whatever, you see, we can tell the registry to hand over all copy. But if you have done your homework, you please exchange with us. And then we will propose a draft order that both of you will see, then we'll pass.
Very well.
Item 31. Item
Thank you.